Serial number 50.
A memo is filed seeking to withdraw this MFA that the matter is settled before the trial court. Accordingly dismissed as withdrawn. Yes. Yes,
Wait, number.
Serial number 19 and 22, both common lots, my lord. You engaged senior counsel, my lord. Today is in Delhi. Kindly out and after 8, any date, may fix my. Serial number 19 and 22.
You are arguing engaged.
Yes, yes, my.
notices.
Notice
not-
not, sir.
Notice.
Trust matter.
When do you want?
After 8, any date. Ma'am.
Post on 12th.
My lord,
Request of learned counsel for the petitioner.
serial number 21, my lords. 22 also, my lord.
21, yes.
A serial number in 21, arising out of the same order, 2 appeals has been filed, my lords. This appeal has to be connected along with MFA number 5067 of 2024, my lords. So it may be kindly,
Take that number, post along with it when,
next Thursday, my lords.
yes. At the request of learned counsel for the petitioner. Yes,
Page number 7, serial number 24 to 29. Page 8, 30 to 35. Page 9, 36 to 38.
Serial number 36, my lord. The office raised the objection.
Hmm.
The permission to post before this honorable division bench and we are, this raised the objection. The matter was posted for single bench, man.
that's what the matter is listed before the court. We'll see when it reaches.
Please, my lord.
We'll see when the matter is called.
Please.
We have to look at the file. What is that the officer said? Yes, next.
Page number
Serial number 37, my lord, week's time may be
39.
granted, my lord, to complete office objection, minor office objection,
The
please.
week's time is granted for complying with the office objections. If the objections are not complied with, the appeal stands dismissed without further reference to the court. Yes,
Page
Macho.
serial number 39 to 42.
Serial number 40, my lord. Only 1 week time may be granted. Yes.
Lord, I represent the counsel for the appellant. An interim order granted by this honorable court was violated. This honorable court, my lord, took cognizance of that. And my lord, the registry was directed to record evidence. Evidence has been recorded. I believe, my lord, the report is on the board. And my lords may have to hear the matter.
I'm unable to take the evidence. What is the recorded evidence before the judicial? I'm
It was
unable to getting because last week has been recording the evidence. That is the reason 1 week time may be granted. We are getting the evidence of recording evidence and
you wait till the matter is called so that you know the court will know what it is.
the evidence was recorded in the presence of my friend.
Then we will see if that is required.
because some documents also marked. I am
That's
not
what
getting
we
that
will
mark.
see. We will see what is the report, what is the case. I don't know what it is unless and until we look at the file. So please wait. Yes, next.
Page number 11, serial number 43 to 45. Page 1, serial number 1 for the teacher, Basavaraja Padilla for petitioner.
My lordship, I'm sorry, apology, my lordship, but Delhi advocate on record advocate, my lordship, and memo is mentioning in.
Huh?
But already.
Okay, leadership, I am on my leadership in this case. Now, leadership, this is the child custody matter in which there was a direction given for shifting of custody. However, the custody has not been shifted, leadership. We just request the matter to be listed before your leadership for tomorrow.
Why custody to be shifted?
Leadership, there is a particular case in which Justice Nagprasan had passed an order for shifting of custody because of the contempt of the wife. However, in that case, the custody was not given for a period of 1 month. We moved an IA in that case, leadership. It may be just listed on tomorrow or any other day, leadership may deem fit.
Let it come, you just like post this matter on Tuesday. Yes.
I'm so grateful, leadership. Thank you.
Basavaraja Padilla, KV Satish.
Petition respondent.
Hmm.
This case, my lord, the husband's petition.
Hmm.
Wife filed a petition, my lord, 125.
Hmm.
An interim application has been filed. That came to be allowed, my lord, granting 16,000 rupees for a month,
Hmm.
12,000 rupees and 5,000 litigation expenses.
Hmm.
Therefore, I before lodge.
12,000?
12,000 rupees per month maintenance
Oh,
and 5,000 rupees litigation expenses.
only for the wife. What is the income of the husband?
Marriage, after 15 days marriage, she left the company. of
What
the-
is the income of the husband?
My lord, she's a agriculturist and is doing coolie, my lord, is having only 2 acres of land. And moreover, my lord, his aged parents are there. and they are suffering from several ailments, and he has to look after his parents also.
Let's see the order. Please come to the order.
The reason starts, my lord, page number 19. There is no dispute between the parties that they are legally wedded couples, and presently they are living separately from December 21. It is also not in dispute that respondent has issued a legal notice to the petitioner on 5/4/23. Said notice, petitioner has given a reply on 19/4/23. On through.
You have not filed your statement of assets and liabilities?
No,
My lord,
submission, Your Honor. According to that, I filed a statement of assets and liability affidavit. According to my affidavit, I stated he is doing the business to lend the shamiana, chairs and others.
No.
And he is having the 8 acres of land.
Why have you not filed?
Lieutenant Counsel, my lord, in the,
If you have not filed, then whatever they are saying, then we have to take it when there is when you are supposed to file as per the judgment of the apex court.
on Sir H. my lord, page 66, I filed a memo, my lord, adopting the objection statements filed along to the main petition, be taken as objection to this application. my
What to
lord.
do?
Yes. Page,
When she's saying that you're having so-and-so income and she filed something on, in a statement of assets and liabilities, you're supposed to file yours. Nobody has stopped you. If you're not filing, that means something you want to hide from the court.
my lord, for
And
the-
why should this court interfere now?
because the learned trial judge might come to conclusion that because
No, your obligation is to file, which you have not chosen to do. What the court can do?
my lord, what is stated, my lord, by the petitioner is in total accepted by the learned judge without, my lord, because no evidence has been let in.
Now,
And
who stopped you from filing your statement of assets? Simple, and question and answer. That is, then you are not chosen to, then will not interfere. Now, from now on, I already informed advocates that will not remand the matters for filing statement of assets and liabilities, because you do know that you have to file, which you have not chosen to. Unnecessarily, the judicial time can't be wasted like this, shuttling between High Court and Family Court.
my lord, for the sake of, my lord, learned trial court advocate, my lord, has not.
Well, it's not for the sake of, he has engaged an advocate, like that he has to do.
8 acres of land is there, Your Honor. 4 acres is a yielded areca garden. Another is 4 acres. 1 acre land is gotten 5 lakh rupees income is there. And is also business. Shamiana, and I declared everything in my statement of assets and liability affidavit, Your Honor. And is also having the Ertiga car and 2 tractors, Your Honor. 1 tractor for lengthy agriculturist. Another tractor is given to the water supply to the villagers, Your Honor. He's having the sufficient fund. He's a only son of that parents, and another sisters is already got married, Your Honor. In my statement of assets and liability affidavit, I clearly stated all the numbers and detail is there, Your Honor.
Please come.
Good.
Agreed with the order passed in criminal, in I number 1 in criminal miscellaneous number 140 of 2023, dated 25/5/2023. By so and so, the petition is before this, the petitioner husband is before this court. Parties are referred to so and so. The wife had filed criminal miscellaneous number 140 of 2023. In this, she has filed IA 1 seeking interim maintenance at rupees 60,000 per month and litigation expenses of rupees 30,000. It is her case that immediately after the marriage, within 2 months, the in-law started to harass her for dowry and wrongfully confined her in the godown. with all the harassment she has to she is forced to leave the matrimonial home and file the complaint before the Mahila Police Station, Shivamogga. He stated that she's staying, now she's staying along with the parents. She's not earning and she requires maintenance. According to her husband, is having landed properties and also doing business and earning sufficiently. The husband, and she has also filed a statement of assets and liabilities to show what is her income. And also she has mentioned about the car, tractor and other mobile and immobile properties of the husband. The husband had filed his objections, making several allegations against the wife. It is his case that she, without any reasonable cause, has deserted him. He simply denied that he's having ancestral agriculture property and having an income of rupees 1 lakh per month. And also the maintenance claimed by her at 60,000. The trial court, while granting maintenance of an amount of rupees 12,000, has fined 5,000 towards litigation expenses. The court has observed that the wife had filed her affidavit of disclosure of assets and liabilities, stating that she had studied second PUC and completed a basic computer course. And she's residing in her parental house. And the husband is carrying business of renting tentacles, etc., having a share in the joint family property, living in his own house belonging to his father. The court has also observed that the husband had not filed the affidavit of disclosure of assets and liabilities, which are within his knowledge, which is mandated as per the judgment of the Honorable Apex Court in case of Rajneesh versus Neha. The court has also observed that when the husband has failed to file a statement of assets and liabilities, the court has to draw an adverse inference as per the judgment. And it is also not the case of the husband that wife is having income to support herself, nor he's a physically disabled man. Considering all this, the court had granted 12,000 maintenance, land counsel appearing for and 5,000 towards litigation expenses. Land counsel appearing for the petitioner. Husband submits that the court had failed, the court basing on the statement made by the wife with regard to the income had granted the maintenance. There was no material before the court. What is the income of the husband? It is submitted that the husband is an agriculturist and he has to support his aged parents and an amount of rupees 12,000. He's not in a position to pay. Further, the wife had stayed for a very short time with the husband, and she voluntarily left the matrimonial home. As such, she is not entitled for any maintenance, Next, when counsel appearing for the respondent, wife submits that the wife had filed a statement of assets and liabilities, and she has categorically mentioned what is the income of the husband and what are the assets. The husband has not filed his statement of assets and liabilities, and court had rightly granted the maintenance. He submits that with an intention to suppress his income. He has not filed the assets and liabilities, and the court had rightly drawn adverse inference and granted the maintenance. He submitted that no grounds are made out seeking interference with the well-constituted order passed by the court. Next, having heard the counsels on either side, there is the material on record. As per the law laid down by the Honorable Apex Court in Rashish versus Neha, the parties have to file their respective statements of assets and liabilities. And in majority of the cases, the parties are not filing the statement of assets and liabilities before the court. And after an order is passed by the court, they're coming before this court, and on the ground that they have not filed their statement of assets and liabilities, they want the matter to be remanded back to the court for adjudication on that. This exercise is not permissible. As the law mandates that they have to file their respective statement of assets and liabilities, it is duty of the parties to file the same, and they can't afford to waste the judicial time by not filing and again asking this court to remand the matter for that purpose. Such an exercise cannot be done. Coming to the facts of the case, in this case, when the wife had stated so many things in a statement in her IA about his income, the husband ought to have filed specific objections to that. But instead of filing the objections to that, he had he filed a memo adopting his objections to the main petition. Then when it comes to the statement of assets and liabilities filed by the wife, she had taken she has mentioned about certain properties, his business, and he has not chosen to advert to the same, and he kept quiet. And the court had granted the maintenance, and this court finds no reasons to interfere. Accordingly, dismissal.
The two adjourned, the three. Then Michael Perez for.
My lord, I filed the memo of service before the office, madam. But it was filed today.
Not there.
It was filed in the morning, the memo of service.
Take that. To whom you have served?
My lord, to Canon Law Chambers, my lord. They are the address.
That's what yesterday it has come up. I said, if it has to be printed, there should be some name.
Yes, my lord. My lord, there's in Varghese Salvin PS is the advocate there, my lord. He has instructed his junior Krija to sign.
What's the name? Take the
KRIJA.
print the name of so and so, poses matter tomorrow. Then counsel for the petition submits that as per the orders passed by this court, he has served the papers on the counsel appearing for the respondent and filed a memo to that effect. The registry is directed to print the name of so and so, poses matter tomorrow. Yes.
The fourth. Sir Hegde Udlamane for appellant.
Appearing for appellant.
Yes.
Lords, I have filed a memo with respect to the notice ordered by this honorable court with respect to R3. Came to the knowledge that my lords, the R3 is already dead. And subsequently, his LR, that is proposed respond number 3A. She also died on 20th for 2020 in view of the COVID. Husband and wife both are married, my lords, but they do not have any children or to proceed with the legal representatives. And moreover, my lords, in the present appeal, specific prayer is not sought for against the R3. So hence, no, to
What
that
is this
effect.
MFA?
MFA is with respect to my lords. Challenging the order made on IA1 under 39 rule 1 and 2 my lords.
Hmm.
Injunction.
Injunction against?
Injunction against the scheduled property members.
And then why are you saying that that's a property now, that belongs to the legal?
No, my lords, the defendants, specifically defendant number 1, he is the main, he is the plaintiff in the suit, my lords.
Hmm?
Sorry, my lords, the respondent number 1 is the plaintiff before the trial court. Injunction is granted in his favor, my lords. So he is made as a respondent number 1 in this present appeal.
Who are 2 and 3?
2 and 3 are the other family members, my lords.
Family members of?
Family members of, say, Lakkamma, my lords, that is the appellant.
Hmm. Suit is for partition.
Suit is for partition, my lords.
Hmm.
So only with respect to that effect, my lords, as there is no specific, the respondent number 1 is the plaintiff and the respondent number 3 is also one of the member. In view of his death and also no loss to that effect, my lords, they anyhow, if the share is to be determined, it will be with the members itself, my lords. So notice against R3 may be kindly be dispensed with. That's the memo which is filed for, my lords, in the regarding first one.
Please come to the cost item. At page number 51. Suit.
Yes, my lords.
Hmm.
Obaleshwara, that is the respondent number 1 in the appeal, my lords.
Yes,
Present appeal.
is the plaintiff in the suit.
Yes, my lords.
You are which defendant?
Sorry, my lords.
You are which defendant?
I am the defendant number, my lords.
Lakkamma.
Lakkamma, Ramaya.
You are, who is the appellant before this court?
Appellant before this court are say Sri Ramaya,
Ah.
Rudresh Gowda, Om Shivaya, Dalamma, Gauramma, Obamma, Ravi Kumar. Totally 10 appellants are there. my lords. Sorry, Lakkamma is the one respondent number 2. my lords. I stand corrected.
Ah.
So in this suit, my lords,
So except Lakkamma, all are the appellants.
except Lakkamma and Obama. Obama and there are several more. my lords.
No,
11.
you say there are 10 appellants. This
Yes, my
the-
lords, 10
altogether-
appellants and 10 defendant, 12 respondents in this also. my lords. 11 is specifically stated and 12 is mentioned as not a made party hearing respondents. But in our the contention which we taken in the memo is that with respect to the order challenged under in this appeal, my lords, we are not specifically seeking against the respondent number 3 in this present appeal. To that effect, my lords, the notice to R3 or R3A, my lords, it may kindly be.
Then
dispensed
that's
with.
it. Where is the memo? That's at your risk.
Memo dated 3rd August 2022, my lords.
Memo dated?
3rd August 2022, my lords.
Hmm.
I may be permitted to hand over office copy to. 2 more IAs also came to be filed on very same day and memo is also filed.
That is there. That substituted service is there.
Substitution service with respect to
A memo is filed. Stating that the office objections. on I number 5 of 2019 for bringing LRs as a respondent number 3A. It is stated that the proposed respondent number 3A died on 2020 because of COVID. They have investigated, they have inquired about the LRs. On verification, they learned that neither Obama nor Narayan Swamy has any children. And as such, appellants are unable to bring any other legal representatives of respondent number 3. Further, the appellants have not claimed any relief against the respondent number 3, Obama, and she is a formal party. Hence, it is submitted that they are not necessary parties to this application, to this appeal. Hence, the name of the, hence the respondent number 3 and proposed respondent number 3A may kindly be deleted in the appeal. Considering the said memo is taken on record, and considering the same, from the array of respondents, so and so is deleted at the risk of the appellant.
Lords, and with respect to paper publication, my lord, substitute,
That is not ordered.
that is not ordered.
Last it is there.
And also one more application is there to bring the LR of deceased appellant number 1, my lords. This also filed on very same. It is filed on 22 April 2022.
When will your appeal be heard with all this?
Lords, from long back, my lord, we've been paying the process fee and also, and somehow again, these two persons, my lord. Only 2 persons were represented in this, my lords, R1, R10A and R10B.
It is IA number 7 of 22 or 2 of 22?
2 of 22, my lords.
IA number 2 of 22 is filed. Taking substituted service of notice to respondent number 6, respondent number 9A, and respondent number 9C. The petitioner, the appellant is permitted to take out notice on so and so all those respondents in Prajavani, Bangalore edition, on or before. What is the other application?
My lords, in other application, my lords, the appellant number 1 is dead, my lords, and his other LRs are already mentioned as other remaining appellants in the present appeal, and his wife, my lords, namely Bailama, she need to be brought on record.
This memo is here. It is here, that memo, give him that office copy.
I believe IA 1 of 2022 to bring the LRs of appellant number.
This is IA1, na?
Yes, please.
IA1, no, this memo to delete them is IA1 or IA?
Memo is only filed as a memo. That is no IA. Appellant number 1, set out died on 24/1/2020.
Yes, yes, yes.
These children are already on record
IA1
as
of 2022 is filed to bring the
wife on record.
Legal representatives of deceased appellant number 1 as the appellant number 1A.
And children.
Notice has to go in this.
No, my lords, appellant, she's the mother of remaining appellant, that is appellant number 3 to A.
Accordingly, IA is IA number so and so is allowed, and the petitioner shall carry out permitting so and so to be transposed, to be completed as appellant 1A, and the petitioner shall make out carry out necessary corrections.
Please, my lords.
Yes.
Serial number 5, Abhinay Vaiti for appellant.
Appearing for R2.
Hmm?
Appearing for R2. Moment.
Abhinay Vaiti.
on 24/11/2023, it was submitted that the respondent died and prayed 2 weeks' time to file the necessary application. Thereafter, it came up 2 times before this court on 9/2/2024 and 23/2/2024. On those 2 occasions, the appellant had sought for time. Today, there is no representation on behalf of the appellant. This is an appeal of 2016. Pose this matter for dismissal on Wednesday. Yes,
Case number 6.
I represent the. Six, right?
why this final hearing is in between? They don't use brain at all. How can the final hearing be in between? All these final hearing matters at 2:30.
My lords, one submission, my lords. I seek for short accommodation in this matter.
2011 matters, no short accommodation. Come at 2:30, we'll see. Next,
Serial number 11. Parted matter, serial number 11.
Respondent,
Kumar
your
Shetty
lordship.
K. For petition.
For respondent, your lordship. The matter was in chambers, your lordship. last.
give that. Where are the councils? What are your instructions?
Your lordship, we are in search of pediatric psychiatrist, your lordship. We will ascertain the doctor's name and furnish your lordship.
At the request of both the councils, pose this matter on Wednesday. Yes,
12. Surprise.
now court has no other work but to again repeatedly hear this matter. How many times it's coming up? What is happening now?
My lord, the child is diagnosed with dengue-like illness and urinary tract infection with severe dehydration. She's admitted at Manipal Hospital since yesterday, my lord. She is on IV. My lord,
It's not about joining her in a hospital, about not joining her in Enhance. It is about when the girl is not well, is a father not supposed to know it. For that, he comes before the court and moves this application.
my lord, he was informed, my lord, by the
I was not
demands itself.
informed. That's a false submission. I was not
Informed
informed.
by Nimham's hospital. Why she is doing this? Is he not supposed to know? First of all, you are supposed to admit in Nimham's hospital. You say that the girl is not well. If she is unwell, is he not supposed to know? For that again, court has no other work. They keep on monitoring what wife and husband are doing.
My lord, it is because of
Well, the school had permitted the child to miss the school. She's negotiated with the doctors and she's taken the child to the school. She's taking the child to the school every day, my lord. 25 kilometers per one side. 50 kilometers the child has to travel to the school every day. There is no necessity for the child to attend the school. at
My
this
lord, there
juncture.
is no negotiation that is happening at Nimhans, my lord. It is the doctor's instruction who said we should not take away the day-to-day activities of the child. Hence, send the child to the school.
No, that
Let
is,
her continue.
let's
That
not,
is-
once the court said it is for the doctors to take care of it, they'll take care of it.
Please, my lord, leave
Whatever,
it at-
the negotiations, whether she has done or not. No, he says that he see the daughter in the hospital.
My lord, the father comes to the hospital. He creates a ruckus. He goes
All
and
these
the
are false
hospital. My
submissions,
lord,
ma'am.
I'm making a submission. He goes to the hospital. He tells the doctor's staff saying that she has absconded with the child from Nimhans. He's making such derogatory remarks on the mother, my lord.
False submissions, my lord. False submissions are being canvassed. Day before yesterday, I visited the hospital. I was not permitted. Doctors said they have to
I
get.
told on the last occasion in the interaction.
It was
I told-
outside visiting
I
her.
told your client, he shouldn't be, what are this anxiety
But
of
he's
your
not
client?
doing anything, my lord. They're not permitting me to even get get
You were
information
not
about.
seeing
the
her
child.
for so many months together.
Let-
For one day, you have not seen her, that you have come before the court and you have made a
My lord,
mention for this matter.
she's admitted in the hospital, my lord. I do not know what has happened to her. I do not get any information from the
And you
mother.
tell that why should she go to the school? No, for taking her 25 kilometers, that is all the effort the mother is making.
But that is a risk on her health, my lord. That's all I'm
My
concerned
lord,
about, nothing
there's
more.
an IA that is submitted, my lord, modification. My lord, kindly refer all the images, how,
I need to file my objections to this application.
What is that, what is that
my lord, it
modification?
is the accommodation at Nimhans, my lord. We filed at the registry as well. There's an IA, the copy is already there.
I
My
received
lord,
a copy this morning.
What is that? What is objection now?
my lord, this is pertaining to the, kindly, my lord, the office copy of the IA for modification of the accommodation that is provided for the petitioners herein. My lord, the IA
that.
copy. The modification, it's filed in the registrar as well in the morning.
How many orders the mother wants the court to pass? And how much of accommodation she requires every time?
My lord, page number 16, my lord. This was the situation of the bathroom at Nimhans as soon as we entered, my lord. There were stools on the toilet seat. This is the condition, and this has led to a urinary tract infection for a 6-year-old child, my lord. She's complaining about abdomen pain, not knowing what the pain exactly is. She's admitted in the hospital with severe dehydration. No food is provided for us. We are ordering from outside for continuous 5 days. We are made to eat outside food from Zomato, Swiggy, all the other online apps. There is no proper, the child's health has been deteriorating. The window is broken, my lord. The saying that it is needed for ventilation. But it is inviting so many insects and pests inside the room. And in the morning, I was flabbergasted to see that there are cockroaches crawling around on my bed, my lord. You could kindly refer to page number 41 and 42, my lord. My lord, page number 32 is the medical record, the blood report of the child. The child has a high C-reactive protein, that is the infection. It is supposed to be below 5. It says it is 12.68, my lord. She's highly infected, living in that environment, my lord. Staying in that environment, and they again make an accusation saying we have not even informed, we have absconded.
I've not been
My
informed
lord,
about anything.
Page number 20, we have constantly been in touch with Nimhans from the time we have gotten out of the school. We have gotten out of Nimhans. I was driving her to school. Page number 18, annexure D, you can see the kid vomiting inside the car. My lord, of course, they'll raise question, why is she clicking pictures? But I am put in a defense position here, my lord. I am supposed to click pictures. The child is terribly sick, my lord. This is affecting her health and well-being, my lord.
So what is the modification?
My lord, a modification
They
of
may
the
want an
accommodation,
accommodation.
my lord.
They may want an accommodation near the Nimhans. I'm agreeable to that.
My lord, we will go to evaluation every day from home.
That is
What you're not understanding is being with the mother, that's what the doctor said. It is not possible for them to treat her. That's what the doctors are saying. Every day, 1 hour, 2 hours, they talk to the girl and the remaining time she is with the mother. Then it takes another 5-6 days for them to get her out of it. And again, the same process goes on. Let the mother tell the court what is to be done instead of telling all the complaints. Let the mother say what is to be done.
My lord, going back to the same accommodation, my lord, will put a risk to my child's health, my lord.
I'm agreeable for a separate accommodation, my lord, near Nimhans. I'm agreeable to that arrangement.
It is not about near Nimhans or away from Nimhans. According to them, she has to stay there. Either she can't be with the father or she can't be with the mother.
These are the
There is no purpose of doing any exercise of this nature.
This is the nature of complaints they raise, my lord, against Nimans. I do not defend that. Do not want to put my child at risk. I'm agreeable for a separate accommodation. Let the child not be sent back to the mother. That is all. It will only frustrate the process. That's all my submission is.
My lord, all of this is leading stress to the child because the respondent showing an adamant behavior and pressing on all of this over and again. My lord, now the child is frustrated to even look at his face when he comes to the hospital. My lord, he comes during
She's
non-visitation.
not looking at him earlier also.
She started screaming, my lord, yesterday. He barges into the room, my lord. He doesn't even
But
ask
some
permission.
baseless allegations are being made.
My lord, we have
The
produced
mother is
pictures, my lord.
brainwashed the child, my lord. That is also realized by this court, my lord. The child is
No, then
explicitly
why
lying.
the father is not giving the time?
My lord, I'm giving the time, my lord. The only
So
concern
if
is,
you're giving the time, you wouldn't have come so many times to the court like
my
this.
lord, now my child is admitted to the hospital. I do not have any information about why she is admitted to the hospital. What is the ailment that she is suffering from? At least that information,
You
if
have
she
to
wants.
earn that affection and whatever that is from your child. This way, if you feel that you have from the court orders and all, you will try to do, you can have something. It's not possible.
Lord, it's
Court
only
can
that,
pass an order.
Lord, I only request that for a direction to be passed, to keep me in the loop. If she doesn't want to communicate with me, let her send it, put it on mail, whatever medical records, whatever treatment that the child is getting, let her put all those
So
records
that
on
you
email.
will give her an advice how to do the treatment or
Lord,
your,
I'll at
your
least know
client
what
is a
is happening
doctor.
to the child, my lord. That is all.
More than your affection or your feelings for the daughter, it's more of a ego tussle.
Lord, that is not with the father, my lord. That's only with the mother. That is.
We
No, that
disagree
is
to that.
equally with the father. The court has
But
interacted with
father's
him.
anxiety is only for the well-being of the child, my lord, nothing more. But the father does not have any information of
That
about
is
why the
what,
child is.
it is not about the girl's well-being. About he should know about what is happening is the only problem of the father.
Lord,
Girl is as it is okay with the mother.
Lord, naturally, I should know what the child is suffering.
No, but you should know. You know what has happened. What are the complaints that are made? In spite of all that, why your client is not understanding?
My lord, I do not. Day before yesterday, I did not even want to see the child, my lord. I wanted to get
With the
information
kind of
from the doctors.
allegations, with the kind of allegations she made against you and which she continues to make, still your client is not understanding that it requires some time and patience.
Lord,
At your age, you need to have patience or not.
my concern is, Lord, I went to at least meet the doctor to get information, my lord. The doctor said if the attendant does not permit us to disclose the information, we don't want to do it. That's exactly what I was told.
No, can't you just wait for some time? On a day-to-day basis, everything, you have no other work?
My lord, I waited for 1 whole year, my lord. There's no
You waited
communication,
for
not even one email that she sends to me.
You waited for 1 whole year. Now, the situation, how it was 1 year back, it is worsened now. So all the more reason, now the court wants to set it right. But you don't want it that way. Every day, one application
Lord,
or the other, you're coming before the
But this
court.
application is not
You
preferred
think
by.
that don't go to the school. Why? Let her stay in Enhanced, let her do that.
That will only
No special
frustrate-
room is required. No, what you want is, anyhow, I'm not having the custody of the mother. I mean, the daughter, let the mother also not have. That
That
appears
is-
to be the attitude.
That's not my submission.
It's not the way. That's not the way it goes on.
Lord, the evaluation is to be done in the absence of the mother, my lord. If the child is to go back to the mother, that will not serve any purpose, is all my submission is. My lord,
That
I'll
the
leave it
court
to the
will-
court, my
That
lord.
the court will take care. So
Please, my lord.
don't
Beyond
go
that, I'll leave it
around,
to the court.
don't go around. Let the mother take care of the child. She will
Please, my
take
lord,
care.
I'll leave it at that. Let there be a direction, my lord, for her to at least put it on
So
email.
when the child was joined in Enhanced?
26th,
26
July.
How many days she stayed there?
5 days.
When did she admit, when was she admitted in the hospital?
30th.
30th. Where are 5 days from 26th to 30th?
29, 30. 30th morning is when she gets admitted. She leaves, she takes her checkout to take her to the school. 26th evening, she gets admitted at
Mother is
Enhanced.
not there with her.
She's there with her.
Mm.
On 30th morning is when they go to, they check out from Nimhans to take her to school. She still complains about
No,
uneasiness.
what is that, every day taking 25 kilometers there and 25 kilometers back? Won't the child be more stressed and with all that? Don't you feel that all this is creating some kind of an effect on her health?
My lord, this was not the suggestion put by me, my lord, to the doctor. The doctor, in fact, insisted upon her going through her day-to-day activities. Only on Saturdays, the doctor
No, but,
suggested.
the mother has to tell the doctors that 25 kilometers, how can they travel? Shall we find out from the hospital that did they tell that, no, you go to the you go to the school, don't stay in the hospital?
My lord, they said subject to the transportation arrangement that is being made. The
That's what
child.
we can understand, I can understand what has happened. No, you created every day for 4 days. You made the girl 4 into 40 kilometers to travel every day.
My lord, on Friday, we came back from school and got her admitted, my lord. Saturday, there was no school. Sunday, there was her dance exam and the doctor says, no, you take her. She has to do her day-to-day activities. She should not miss out on it. Only on Monday, we go to school. She was already sick by then, my lord. The entire room, the window is broken. There are insects, there are mosquitoes, there are a lot of things that has got.
Nobody is staying there in Enhance.
My lord?
In Enhance, there are no patients in Enhance.
My lord, there are, my lord, but my lord, for traveling,
Should
it
have
would have
been brought to
cost.
the notice of the hospital authorities, saying
It
that
was
things
brought
are
to the
not well.
notice. My lord, it was brought to the notice immediately.
They will attend to that.
My lord,
No,
even they said.
no, if there is a problem, solution is not going away from the problem. It has to be attended, and the authorities have to attend it. They have to attend, and they should do what is supposed to be done. Solution is not, like if you have a problem, genuinely, if she has to, if the mother feels that it's a problem and the hospital is not good, but the treatment is good, will they go away from there?
My lord, of course, maybe the travel might have caused stress, my lord, but what explanation can I give for UTI, my lord? She's a 6-year-old kid, my lord.
So if something is not right, it has to be set right. For that, there is no complaint. If the washrooms are not properly cleaned, it's not that you can't tell the hospital people to do it. When you're paying for this, and you have, they have to give you the service. And that can't be a problem. If something is giving you some kind of any inconvenience, bring it to the notice of the hospital authorities. They will attend to it. And let her, can't she, for 6 weeks time, for the health of the girl, can't she have that patience to wait there without doing all this exercise? Can't she tell the hospital that traveling for 40 kilometers a day makes a lot of difference on her health? No.
My lord, in fact, staying there the whole day and not taking away her entire day-to-day activities will again result in various psychological problems that she doesn't even have now. It might develop. My lord, the respondent goes on, says, I care about the well-being of the child, and they press on general ward. Now they say, no, get back.
No, is it your submission that the doctors are somewhat are inimically disposed against your client?
No,
That
my lord.
they're telling all that.
No,
So
my lord.
as for your girl's mental well-being, for that only she is there, and the doctors are more concerned with it. Let her mother not have her own assessment basing on Google knowledge. The doctors will take care. They know what to do. And
Indeed, my lord.
precisely, no, so much of exercise is done before putting the girl into the hospital. In fact, this court has spoke to the doctor for 1 hour. Then only this decision is taken. So this court do not want any kind of applications again before the court, neither from you nor from him, for the next 6 weeks. And cooperate with it, and it should complete in the interest of the girl. And all these both the claims do not weigh before the court. If some problem is there, I'll write in the order. If any of that should be attended by the Enhancement, they will do it.
But my lord, we completely acknowledge with the mental well-being of the child, my lord, but not at the cost of the physical well-being of the child, my lord.
That's what physical well-being, how? You're telling about the 2 things. For 2 things, you say that you will not take the treatment. That will tell,
We are
that you
taking the
ask them,
treatment, my
that
lord.
you ask them, will also then in this order also, this court will point out what all the complaints Nimans is a big institute. We'll ask them, why are they doing all this?
Indeed,
And
my lord.
don't come up with any other application saying that some modification is required. And that will be viewed very seriously, and you also. For everything, don't come to the
But
court.
let there be
Please
only
wait
request.
patiently for the next 6 weeks till the treatment is completed. Don't come up with any kind of complaints. Just wait for it.
Only request, my lord. Let them put it on mail, my lord. I'm also on the email there. My friends are also on the email. There is also an email thread. If she's
Then don't go to the hospital and do all this ruckus.
I won't, my lord. I won't. I only wanted
Inform
to
him
get information.
what is she doing.
Indeed, my lord.
Don't have to tell him what treatment, what tablets are being given. How is she doing on a day-to-day basis is enough.
Indeed. My lord, a direction could be given for him not to come to the hospital and create a ruckus.
This is unfounded allegations, my lord. I'll take serious objection.
Very unfortunate. Looking at the girls' health and all, both of you are, this is a manner in which
But she's trying
both
to
of you
keep
are
away the
fighting.
child away from me, my lord. She's
Your client has to have that anger management and that aggression should come down.
my lord,
With that
he's-
aggression, he cannot achieve anything. Can you forcibly take the daughter?
But the only concern is the physical well-being,
Is-
mental well-being of the child, nothing more than.
No, you're spoiling it.
But
No.
I only wanted the information about the child, my lord, nothing more. My lord. That was the anxiety of the father, nothing
And
more.
the next time, whoever comes with an application will dismiss it with exemplary cause for the next 6 weeks.
That may be
It
specified.
should, it should go on. This court on 24/7. Earlier, when an order is passed directing directing the parties to admit the girl in Nimhans, directing the mother, one request was made stating that the special room is not available. That request was considered. And now came up with another modification application saying that the washrooms and the room are not clean, not well maintained. And as such, the girl has developed the urinary tract infection and she is admitted in the hospital. Husband's complaint is, the father's complaint is that he do not know about the health condition of the daughter and he is not permitted to see her. And he came to know about this through Nimhans. Now a petition is filed seeking modification stating that the order dated 10/7/2024 may be modified and permitted the child to stay at their residence and visit Nimhans for psychological evaluation as and when required. First, with regard to the unhygienic conditions that are referring to in this petition, with regard to the washrooms and the room inside the rooms also. First, before coming to this court, they should have brought this to the notice of the hospital authorities. And it is the responsibility of the hospital authorities to see that the child lives in a hygienic condition in the hospital. From the affidavit, it do not disclose that such an effort is made. Every day, the distance between the school and the hospital is 25 kilometers and 25 kilometers up and down. From the last 4 days, 3 days, the girl is made to travel. That whether that contributed for the dehydration and the stress and other things, the mother is not much concerned. But according to her, only the hospital conditions have contributed to this. When before admitting the girl in Nimhans, when this court has spoken to the doctors, and after an elaborate discussion with the doctors, when they have categorically said that unless and until the daughter is joined as an inpatient in the hospital, it is very difficult to understand and treat her. The mother, on one reason or the other, she is coming up before the court saying that the girl will be staying at the house. The father, on one reason or the other, he comes up before the court with the counter allegations. This is very unfortunate that both the mother and the father are not at all, are not behaving are not taking action or their actions do not appears to be in the interest of the minor. When the mindset with and considering the issues, this court had referred the girl. They have both of them have no concern for that. The husband is more on the visiting the girl, and the father is more on visiting the girl and on seeing the girl, and the mother is worried about her school and other issues. Both of them are not able to understand what is important for the girl, and if the present state of her her mental state is not a proper counseling and a proper treatment is not given, it would have an impact on her entire life. The mother, the hospital authorities shall see that it is a responsibility of the hospital authorities to see that the patients live in a hygienic condition. And if as complained by the mother, if the conditions in the hospitals are not hygiene, it should be their responsibility, and immediately they should take care of the particular conditions. Should take care of that and should rectify the same. Till the next 6 weeks, except what the doctor says, neither the father nor the mother has any say in this, and they should not come to the court for on each and every until the 6 weeks period is completed, and till the report is given by Enhancement, both the parties shall cooperate with the hospital authorities. Now it appears that the daughter is in the hospital. The mother shall update the father about her health condition, and the father shall not on his own do the kind of, shall not go, he has no visitation granted by the court, and the daughter is in the custody of the mother. He cannot just like that go to the places he cannot visit the child as and when he wants without the permission of the court. Pose this matter after the report is received from the Enhancement. Yes.
Maybe recorded that it's part heard.
Huh?
Maybe recorded it is part heard. Lordships have shown indulgence, my lord. Maybe record is part heard. Because after
Already part heard. Is it not part heard?
Great.
Yes. Pose this matter as part heard. Oh, disposed of. Yes, next.
Till number 13.
The petitioner, my lord.
Hearing for respondent, my lord.
Last occasion, my lord, I filed my affidavit. This honorable court has directed me to file my affidavit. Accordingly, my lord, on the last occasion, I filed my affidavit.
Now I am filing counter affidavit, my lord.
Where is the affidavit? Where is the counter affidavit?
Filing counter.
What is that this court has asked you to file? Huh?
This court asked me to file an affidavit, my lord,
That?
saying that, my lord, at the rate of 8,000 rupees, my lord, how I am going to pay that amount until the disposal of this writ petition. That is on 27, my lord. Accordingly, I filed an affidavit, my lord, how I am going to pay that amount. By giving calculation, what is the amount I am entitled to? Para 8 of my affidavit, my lord, stated what is the total amount payable, my lord, at the rate of rupees 8,000.
Now, how much is the maintenance granted now?
My lord, maintenance was granted at the rate of 17,000, my lord.
17.
Yes, my lord. After hearing, my lord, this honorable court say, my lord, I requested, my lord, that I'll be able to pay 8,000, my lord. Then this honorable court directed me to file an affidavit, my lord. Under what terms I'm going to pay that amount. In fact, my lord, for the first 31,550, my lord, that I'm going to pay today.
What are your objections to this?
I'm filing counter affidavit.
What is the age of the child?
Pardon?
What is the age of the child?
3 years, my lord.
Yes. Now you're saying so many things with regard to the income.
Yes, my lord.
Uh,
I have produced the documents here also.
Hmm.
Why I have not produced, I have argued the matter on that day. Because I was on post-maternity work and my child was very small and the
And
petitioner was
how,
not.
how he has, how, have you filed any objections to that?
For the document which has produced, my lord, before this honorable, no, I have not filed, my lord.
Why?
With these documents were not produced before the trial court. Filed it along with the memo, my lord.
So,
Before the family court, he has not produced the document. what
Because
has
he was
produced
not-
before
what is
this-
your documents? Whether maybe he's producing it,
I'll
You're
file-
for you to say what it
I'll
is.
file my objections.
What you will file? How many times the matter will come up?
My lord, he has filed only on the last
I
occasion.
had
my
served
lord.
the copies also, my lord. Before 3 months only I had served the copies. All the copies are
Thereafter, my
served.
lord, first time it had came on the 27th, my lord, I'll file my formal objections. Then these documents were not part of the family court, my lord, you would have filed along with an application, my lord.
No, why did you not file your documents?
I filed these documents along with my petition, my lord. Along with my petition, whatever the documents, I have filed, my lord, almost around 300 pages of documents.
So no, he has not filed any other document, have you, which is not filed by you?
No, which has not, he has filed the documents, my lord, some printout of the websites, printout taken from I am posing a photo with near the garden, posing a photo near the car. These documents were
Here the,
produced.
not somebody's car, his own registration number, yes,
Making my
his own
submission.
everything, all his belongings, not somebody's car, somebody's photo, not somebody's. Everything belongs to petitioner and family.
This is such a simple issue. Why unnecessarily these cases are made so complicated? The court do not, no, you know, as per the Supreme Court judgment, what you are supposed to file. And everything will reveal what is your financial status and all. That's
I
the
have
whole
filed that.
purpose of it.
I have filed before
No.
this court. I have filed before the family court. I have filed both. He has not filed it before this honorable court, asset and liability
I have-
affidavit.
As I said,
Before the
there
trial
is no
court,
need to file
I'm
here.
making
I
myself-
already filed there, my lord.
Please let him complete. Yes.
Before the trial court, my lord, they just filed an affidavit. No documents have been produced. Rather, my lord, I produced
So
subsequent.
you are saying for whatever she alleges about your income, that she should file. Where from she will get to file?
No, I'm not asking, because she has not filed any assets and liability affidavit.
You have not filed.
I have filed in my
Affidavit.
as assets and liability, I have filed my part, my lordship. Why should I
Document-
file his assets and
These
liability?
documents were not produced before the family.
Because
court.
why I have not,
It is not his document, that is your document.
Yeah, he has not produced it before the family. court.
because he was not taking care of the cases there in family court and I was under post-maternity work. My child was very small. I was unable to procure the documents. When he is not showing the interest, he was coming to the family court every time. He was not doing any work. And why, from where I should bring?
She has filed 4 cases against me during the same period, my lord.
No, let's not go into that. Please come to the, this is not going anywhere. Please come to the order. We'll see and we'll pass order. Please come to the order.
My lord, the 916 of 2024, my lord. The reasoning, my lord, starts at page number, first, 916,
916, what is 916?
WP 916. Page number.
Page number 63.
65, my lord, is the reasoning. The petitioner claims, may I read, my lord?
Yes.
The petitioner claims that she is the legally wedded wife of the respondent and their marriage was solemnized on 11/11/2020. In their wedlock, they have a male child, Master Panvit Raj, born on 11/8/2021. The petitioner produced birth certificate of the child, which reflects the same of the petitioner and the respondent and parents of the child. The child is under her care and custody. The petitioner relied upon marriage invitation card and marriage photographs in support of her case. The document produced by the petitioner prima facie shows her matrimonial relationship with the respondent. The petitioner claims that the respondent, even after having sufficient means, neglected and failed to maintain her and the child. The respondent is having properties worth of crores and is capable of maintaining her and the child. The petitioner claims that she has no independent source of income and she is depending upon the respondent along with the child for maintenance. The respondent is bound to maintain her and the child, and he is capable of paying rupees 50,000 per month for their maintenance. The petitioner relied upon a copy of the complaint lodged before so-and-so police station by her mother. The petitioner also produced the statement of the respondent and his brother given before the police officer. The respondent in his statement before the IO admitted that he is having a male child in their wedlock and also admitted his matrimonial relation with the petitioner. The statement given by the respondent before IO shows that reconciliation that references panchayat was held. The contents of the statement and complaint given before the police officer shows that petition respondent are residing separately due to matrimonial dispute and their material and the marital dispute has reached the police station. The petitioner has not produced any document to show that the respondent is having property worth crore of rupees.
No,
and
first of all, we are on the point whether what is wrong with the order passed by the court. Can you file a petition to review the order?
My lord, there are review the order, my lord, change circumstances. I filed up in 127, my lord.
Is it maintainable?
My lord, where the court comes to the conclusion, my lord, that I got worth.
In a criminal miscellaneous number 340 of 2022,
Yes.
filing an order to review the order of the court, is it
It's
maintainable?
maintainable, my lord.
Please show the judgments.
Mm. I kindly pass over, my lord, I'll just.
That's the only issue, nothing else.
My lord, there are two other applications, my lord, which I filed to reopen and recall.
That also we'll see.
My order has not been passed, my lord. The matter was posted for judgment.
Yes, next. Pasor.
Petition matter, case number 14. 8. Then
Appeal for the response.
the order.
IA non-filing of acknowledgement for having paid costs of rupees 5,000.
I received the call.
You
received the
received the
response.
cost. All the respondents are served?
Yes, ma'am.
Yes.
But the,
I appear for the contesting respondent 9 to 14 minutes.
not I am for the plaintiff, not. Plaintiff appeal.
Plaintiff's appeal, yes.
Not the plaintiff filed a suit for partition
Hmm.
before the trial court. In respect of 69 properties.
Yes.
Lordship may kindly see, my lord. The genealogical tree is placed at page number, my lord.
What is this, who are these 9 to 12? They are purchasers or the
They're
joint
all
family members?
family members, except respect for 21. 21.
Hmm.
All are my lord, family members, joint family members.
Hmm. What is the IA file?
I have filed for the temporary injunction not to alienate the suitable properties.
Hmm.
Initially, the injunction was granted. So expert injunction was granted. After appearance of the defendant 9 to 14, they filed a detailed objection and reserve judgment.
And
Their
is it
contention, my lord,
self-acquired property?
yes, their
They have
contention,
acquired the property.
no, their contention is there was already a partition in the year 1956. 1956.
Hmm.
Based on the property, partition, some of the properties has fallen to the share of those who are all parties in the partition deed. That is not their contention.
Hmm.
Our contention is it's unregistered partition deed. We are seeking a declaration of that partition deed null and void. We are not binding on the, we are not signatories of the that partition deed, and declare that partition deed null and void. That is our main prayer also.
Where is
Blood,
where is the plane?
Plain blood. Page number 35, document number 2. Your lordship may kindly see the page number 40, my lord.
No, where is that relief you're saying that the declaration and
Now,
all?
my lord, after my lord, the injunction rejected, I filed amendment application.
Amendment is allowed?
Amendment is pending.
Pending, not yet. I
Pending.
objected.
So what is,
Officer.
as of now, the suit that is stands now is about seeking partition.
Partition. Nino Malad, I filed an application is pending.
No.
Now, the Lordship can kindly see page number 40 for a moment.
Hmm.
Gina's country.
Yes.
Even my trial court said, some of the properties are in the name of propositors, Venkatappa. Some of the, still Malad is in the name of great grandfather of plaintiff and defendants.
What is your name?
My name Malad is Ashwath Reddy.
3.
My name is
Not that.
Ashwath Reddy died.
Last column.
Ashwath Reddy, Malad.
Ashwath Reddy, second son's son, grandson's son.
One
Second son's son. So
Anil.
grandson of Venkatappa.
Ashwath Reddy, yeah.
No, no, we'll see from the cost title. Come to the cost title
Of the appeal, Malad.
of the, no, from this,
Plain.
from your plaint.
Plain.
Hmm.
Page number 35, Malad.
Hmm.
Ashwath Reddy,
According to you, the property belongs to your grandfather.
grandfather. Grandfather, 4 children. Therefore, Malad, I'm asking Malad, Lordship
Yes,
kindly.
from this you can show me, that's why I'm asking you.
Yes, Malad. Page number 40, Malad.
Hmm.
Gina country. Venkatappa is the great grandfather of the plaintiff.
Yes.
His Malad is 4 children. One is KV Anmap Reddy.
Hmm.
Second one is KV Venkatram Reddy.
Hmm.
KV Ashwath Reddy and KV Narayan Reddy. Narayan Reddy, no issues, Malad.
No, 1 minute.
Married.
No, all the sons died.
All the sons died.
Hmm.
All the grandsons.
All the sons and the wives also died.
They were died. Died.
Wives also died.
Died.
Now, second son, second son's
Son, Malad.
son is you.
K. Lakshmi, yes, Malad.
No,
Grandson.
Grandson, Malad.
what is your name?
Ashwath Reddy.
K.
Malad.
Ashwath
Yes,
Reddy.
Ashwath Reddy. He is, Malad.
Where do you find his name from the genealogical tree?
1 minute. Malad, it is, Malad, the grandson of KV Anmap Reddy.
Hmm?
Grandson of first KV
Oh, it's a
Anmap Reddy.
bottom, yes, I
First son,
missed it, yes.
First son, Ashwathamma,
Hmm.
KV Venkatram Reddy, K. Lakshmipad Reddy, then Malad K. Lakshmipad Reddy, son Malad KV, K. Ashwatharan Reddy. He is the plaintiff, Malad. Second son, Malad. Second son of Venkat Reddy, Venkatappa, his grandson. Malad, no, Malad.
No, what about the other sons? They do not have any issues.
There are issues, Malad.
Where is that? Only that this appears to be pertaining to your the first Hanumappa Reddy's sons.
Yes, Malad. And others, Malad, Venkatram Reddy's son is Ashwath Reddy. And KV Ashwath Reddy's sons, Malad, are the Shankar Reddy.
Venkatramana Reddy is
Shankar Reddy, Rajshekar
he's
Reddy.
having 2 sons and 1 daughter.
All are the dependents. Except Malad, the KV, KL Ashwath Reddy, others are dependent.
It is issueless.
Issueless is Malad, the
3 and
KV
4
Narayan Reddy.
issueless.
KV Narayan Reddy.
3 and 4 both.
No, 3's son is defendant number 20, respondent number 20. 3's son.
No, if you look at the tree, 3 KV Ashwath Reddy, so and so, KA Sethuram Reddy.
He is the defendant number 20.
Yes.
He is a 20, defendant number 20. He is alive, my lords.
He is alive.
Sethuram Reddy is alive. He is a respondent number 20.
Sethuram Reddy do not have kids, any issues.
Yes, no issues.
He's a party.
Yes,
The party,
madam.
he's a
His
party.
defendant number?
20.
20, Malad.
Defendant number 20. Now, second, these 3, 1, 2, 3, the second son's children, Venkat Reddy, Kalavati, Lata, they are
They are the parties here.
which
They're all
parties?
Kalavati,
Venkatesh Reddy, Kalavati, KR Lata.
Yes, Malad, that is they are Malad, the 17, 18,
17, 18,
Venkat Reddy,
19,
Kalavati,
19,
and
17,
Malad,
18, 19. madam.
Lata,
17, 18, 19.
19. He is appealing for.
Next 2, this is done. Then coming to Hanumant Reddy's children. You are the second one.
Yes, Malad.
Hanumant Reddy had, again Hanumappa Reddy had four sons.
Yes, Malad.
You are the
Sons and one
second
daughter.
son's.
3 sons and 1 daughter.
And 1 daughter.
KV Venkat Reddy,
One daughter, yes.
K. Lakshmipad Reddy,
Hmm.
K. Shankar Reddy,
Hmm.
K. Satyanarayana.
Hmm.
Satyanarayana.
Satyanarayana, she
His
also died.
grandchildren are aged all 60 years.
Yes, ma'am.
Yes.
And now you are seeking partition now.
But what about, madam, this is very long, very big property, 69 properties are there.
200 and add acres.
200 odd acres. But,
No, 200
yes,
odd acres is fine. You are seeking, no, please come to the order. I understood please come, where is the order?
orders, blood, page number,
82.
blood, page number 21 starts. with. Reasoning, blood.
82.
Para 27, page number 27.
So now the grandson is there, they are all great grandsons.
Yes, ma'am.
Venkatappa's one grandson is there now.
Yes, yes.
Remaining all are great grandsons.
Great
Yes,
grandsons.
sir. And widows of son-in-law.
Actually, madam, 1956 party is unregistered party.
We'll look at the order.
Yes. Para number 16 starts, madam.
Now, when did this Hanumappa Reddy died?
Hanumappa Reddy means blood, the first son of Enterprise.
When did he die?
Maybe very long back.
That doesn't.
Prior to 56 only, my lords.
Huh?
Prior to, after his death only, that partition was entered into. Prior to 1956, admittedly.
It's all disputed question of law and facts, my lord. In the RTC matter, there is no similar single entry to show that the partition has been taken place. Only except, my lord, 1950 is unregistered partition.
What is this OS number 369 of
That is
2017?
not different number 10 has filed. With different number 10 filed a suit against
Partition.
his family.
That is also partition suit among their family. members,
his family one.
Based on his partition deed.
They are settled, my lord.
That is the basis for all this.
Yes, yes.
What is the date of that partition?
Main partition among the propositor's sons was 10/6/1956.
1956. Now in this suit of 369 of 2017 also
By
refers
virtue
to
of
that.
that partition deed, my lord,
No. OS number 369
Yes, yes.
2017 also refers to this partition
yes, yes,
only.
that is
10/6,
the observation made by
1956.
the court below.
Please read from the reasons.
Point number 1. The person has to establish prima facie case balance of conveyance and irreparable loss and injury to succeed in an application seeking temporary injunction order. With this prescription, this court intends to proceed with the fact and circumstance of this case. The plaintiff has filed a suit for partition, for the relief of partition and separate portion in respect of 69 suitable properties, and has also contended that the defendant are trying to alienate the suitable properties to third parties. On going through the amendment made by the parties, there is no dispute with regard to the leadership. It is also not dispute that some of the suitable properties were stood in the name of Venkatappa. This is very important. The partition taken place in 1956. The question of stood in the name of Venkatappa does not arise at all. That is the propositors. It is the context of the plaintiff that there is no partition in the joint family. On the other hand, it is the specific case contesting respondent that there has been partition and the respective parties acted upon the partition and they had been enjoying their respective shares. On going through the RTC extract furnished by the plaintiff, go to show that there were number of mutation entries. The plaintiff has not furnished the single mutation entry. The plaintiff has not furnished the document to show that all the suitable properties were belong to Venkatappa. That is his great grandfather. He has not averted that what were the properties stood in the name of Venkatappa, what was the income of the joint family, and on that basis, and the other properties were purchased and when those properties were purchased. They're all disputed question of law. That only based on the trial only it can be looked into. On going to the order sheet plain written statement, other passed in OS number so and so. There is a recital about the earlier partition as contended by the contesting defendant. This fact has not been disclosed by the plaintiff. The contesting defendant placed reliance on certified copies of the 3 sale deeds dated 11/11/23 and 6/1/2014, wherein the plaintiff along with his wife and children sold some of the properties. There is a recital mutation number IHR 2 of 85-86 in those sale deeds. It means the plaintiff had knowledge of the mutation entries in the year 1985 itself. He has suppressed the material fact before the court. According to him, some of the properties stood in his name. Some of the properties stand in the name of contesting defendant. On what basis those entries have been made by the revenue authorities have not been explained by the plaintiff. The granting of temporary injunction is an equitable relief, and who seeks relief, equity should do the equity. But the present case, the plaintiff has not disclosed material fact before the court. It is to be seen from the record that other defendants have also sold some of the property, property. This court may be up to his signature. In for that, there was a party among the parties, and they have acted upon it.
Please come to the objections filed by them or the petition to vacate that injunction. Where is that?
To return statement. Document number 3.
3 or 4?
3 minutes.
Page number 94, I think.
Copies.
Statement of objections filed by defendant numbers 9, 11 to 14.
Yes, ma'am.
But in,
Page number
it is
94.
in my copy, it is 70.
It is 94 in this.
The only defendant number 9 to 14, they are contesting. Other defendants are supporting the plaintiff. Only one family is contesting now.
When was the mutation carried out in 1974?
74 minutes.
In 1974.
Yes, ma'am. As
Some
per
of the
that.
lands are in the name of Venkatappa
Yes.
and the remaining lands are on the name of all other parties.
No. All the properties are settled by virtue of the RRT proceeding in the year 1974, based on a 10/6/1956 partition deed only. Even one of
The revenue record speak about it.
mutation.
No.
I produced before the trial court as many as 42 mutation entries and 11 RTCs and sale deeds from document 4 to 20 are the sale deeds which were sold by the plaintiffs and defendants supporting the plaintiff also. Their
How
shares
can,
were
how
sold.
can the plaintiff sell the property when it is a joint family?
That is what the trial court observes, my lords. And they had a knowledge about it. All the properties were settled by virtue of 1956 partition deed and 1974 RRT proceedings. And then there is a registered RRT proceedings conducted by a Tahsildar. Each shareholders was allotted certain properties and it was not disputed upon. Based on those documents only, even this plaintiff has sold as many as 6 properties. And some of the properties were leased to, presently also they have leased to the third parties and getting the revenue of more than 4.5 lakhs per month, per year. And this property,
No.
it is a disputed fact for them. It is the fact before the trial court. And my lord, also there is a fact, I am only the son. All other family members are 3 sons, 4 sons, 5 sons, and their great grandsons are also divided among themselves. Their properties were settled, sold, and some of them was.
Are you speaking about the defendant number 20?
No, my lords. Defendant number 20 is the.
You appear. You appear for whom?
I appear for 9 to 14, my lords.
9 to 14.
9 to 14. 9 is my mother. 10's mother is a 9. 9 is daughter-in-law of wife of third defendant of Hanma Reddy. So 9 is a mother, 10 is her son, sole son, and 11, 12, 13, 14 are the wife and daughters. 10A is only son for that family. So I am before your lordship. That is a exit.
Please come.
But 1 minute, Malak. Even when any mutation artists or the records of rights, there is no whisper about the partition taken place in the year 1956. Because very big family, Malak. Some properties stand in some properties, some properties stand in the name of some other parties. That is family arrangement only. No partition has taken place. 1974 alternative procedure, why it has been taken place? On those days, there was the ceiling limit was there in Karnataka, Urban Land Ceiling Act. Because that reason, it has been taken place among the family, not for the partition. To avoid ceiling limits, that has been taken place. There is no single signature of any property, any parties in that RRT procedure as well as the 1950s partition also. Let them produce 1956 property, the partition deed. So Lordship may kindly verify whether any one of the defendants or not any one of the family members signed on the partition deed or not. That has to be verified into. Then only this court can come to a conclusion that there is a partition in 1956. There is no single signature by anybody.
Yes.
Anybody. It's only a family arrangement has been taken place. Unregistered partition deed. That too, in the year 1950s, they were not born at all. Some of the members. How we can know whether partition taken place or not? Some properties, not all the properties. Some properties standing in the name of plaintiff. Some properties standing in the name of other defendants.
Yes.
Only based on what is why it has been come to their names. After death of father.
Before this court
After death of their father.
All that are not necessary before this.
After death of their father, it has inheritance has been come, not but through the partition. Let them show a single document in the revenue records. Partition taken place in the year 1956 or through the RRT proceedings. No mentioning in the revenue record whether the partition taken place or not.
Yes, please come. Agreed with the orders passed in I number 1 in OS number 113 of 2021, dated 14th November 2022. The plaintiff is before this court. The plaintiff had filed a suit for partition and separate portion of 1/4 share to the plaintiff and their father's 1/4 share for the suit scheduled properties by meets and bounds, and also grant a cost and other such release deemed fit, that is the relief sought by the plaintiff. The suit scheduled properties runs into 60 items.
69.
69 items consisting of about 200 acres and odd.
And above 200.
200 acres and odd.
Yeah.
The case of the plaintiff is that the property originally belonged to one Venkatappa alias Venkat Reddy, who is the great grandfather of the plaintiff. Said Venkat Reddy Venkat Reddy had 4 sons. And the first son has the first son had 4 sons.
No, 3 sons and a daughter.
Where is Lakshmi Pati Reddy?
No, last one, Satyanarayanamma. 4th is Satyanarayan.
Satyanarayanamma. The first son had 3 sons and 1 daughter. And the first son of the Venkatappa has 4 sons. Hanumappa Reddy, KV Hanumappa Reddy, KV Venkatramana Reddy, KV Ashwath. No, or else you do this. As per the family tree is, the genealogical tree is as below. This extract there. This plaintiff is the great grandson of Venkatappa. That is, his first son, KV Hanumappa Reddy's second son, KH Lakshmi Pati Reddy. His son is the plaintiff. It is a case of the plaintiff that during the lifetime of the great grandfather, the grandfather of the plaintiff and grandfathers of defendants all are living in Hindu undivided joint family and were enjoying the suit scheduled properties jointly. After the death of great grandfather, the plaintiff, grandfather of the plaintiff, his first son, KV Hanumappa Reddy, was looking after the joint family affairs as Karta. And the revenue documents are transferred in the name of said Hanumappa Reddy. And some properties are standing in the name of deceased Venkatramana Reddy and Ashwath Reddy for revenue purpose. And it is the case that after his death, the members of the joint family have inherited the said properties. It is stated that due to the misunderstanding between the co-partners of the joint family, in spite of several requests made by the plaintiff, his request for partition was not considered. And the defendants are totally neglecting and refusing to share with the plaintiff. They're taking advantage of the revenue documents stand in their name. And they have colluded with each other. And without the knowledge of the plaintiff, they're going to alienate the sue schedule properties. If they succeed in that, the interest of the plaintiff would be, it would cause irreparable loss to the plaintiff. And accordingly, he has come up with IA seeking a direction to the respondents not to alienate the sue schedule properties. In that, the defendant number defendant number 9 to 14 had filed their written statement. It is their case that the property was partitioned way back in the year 1956. And the respective shareholders got the properties mutated in their name and were enjoying the same. According to them, the plaintiff himself has sold some of the properties fell to his share by getting the revenue records mutated in the year 1971 through RRT proceedings. According to them, the partition is well within the knowledge of the plaintiff. It is their case that all the family members are enjoying their respective shares as the same was partitioned in the year 1956. And there is no joint family status existed as claimed by the plaintiff.
We are supporting the case of the plaintiff. We are also supporting the case of plaintiff.
They were all placed ex parte before the trial court.
Now they have filed an application. Written statement are active. Separate statement also. Active. No, they have all, everyone has filed.
It is their case that suppressing all these facts, the plaintiff has come before this court, has come before the court seeking the said relief and is not entitled for injunction as he has suppressed several facts. By order impugned, the court had dismissed the IA 1 filed by the plaintiff seeking injunction, restraining them from alienating the property. The court has observed that defendants number 1, 2, 4, 6, 16 and 18 are placed ex parte. And the 3 and 20
We also filed application.
8A to C, 15A to C, and 9 to 14 contested the matter before the court. The court had discussed about the genealogical tree. And about the contention of the defendants that there was the contesting defendants that there was a partition in the year on 10/6/1956. Court has also observed that the defendant number 3, the defendant number 17 to 20 and the plaintiff along with his family members sold some of their properties to the third parties. That is suit schedule item number 43 and the land in survey number 133 was purchased by H.S. Shankar Reddy, That is Venkat Reddy's grandson. And those properties are his self-acquired properties. After his death, his wife and children have been enjoying the said properties. The court has also observed that one of the contesting defendants filed a suit for partition, that is, who is the 10th defendant's son, in OS number 369 of 2017, wherein it was admitted that the partition took place in between Venkatappa's 4 sons.
In that matter, we are not the parties, only their family members. Within the family, they are filed.
The court has observed that the plaintiff has not furnished a single mutation entry. The plaintiff has not furnished any document to show that all the suit scheduled properties belong to Venkatappa, that is the great grandfather. And he has not averred what were the properties stood in the name of Venkatappa, what was the income of the joint family, and on what basis the other properties were purchased. The court observes that on going through the order sheet in written statement and orders passed in OS number 369 of 2017, there is a recital about the earlier partition as contended by the contesting defendants in the suit. The fact has not been disclosed by the plaintiff. And the contesting defendants have relied on a certified copies of the 3 sale deeds dated 11/11/2013 and 6/1/2014, wherein the plaintiff, along with his wife and children, sold some of the suit scheduled properties. There is a recital of mutation number IHR 2/8586 in those sale deeds. The court observes, basing on this, the court has observed that the plaintiff had knowledge of mutation entries in the year 1985 itself. He has not stated anything. There is no whisper in the order, in the pleadings about the same. On what basis those entries are being made by the revenue authorities have not been explained by the plaintiff. The court has further observed that the granting of a relief is an injunction is an equitable relief, and the person who comes to the court should come with clean hands. The court has come to the conclusion that there is suppression of facts by the plaintiff. Then the court has considered the other aspect that the revenue records are for more than 30 to 35 years. Now he has come up before the court stating that the defendants are illegally trying to alienate the suit scheduled properties on the basis of revenue entries. And at this stage, court cannot presume that there is the joint family exists, and in temporary injunction cannot be granted. The court has felt that there is no prima facie case, balance of convenience, or irreparable loss to the plaintiff. Further, what he is seeking is 1/36 share in the suit scheduled properties. For such share, no injunction can be granted for the entire properties. And grant of injunction, the relief of injunction cannot be granted, and accordingly dismiss the next para. Land counsel appearing for the plaintiff submits that when it is a case of the plaintiff that the property is a joint family property, and the members of the joint family are going to alienate the properties, then the court ought to have granted an injunction in favor of the restraining the defendants from alienating the properties. If the said order is not granted, it would unnecessarily lead to multiplicity of proceedings, and this particular aspect was not considered by the court. Then with regard to the sale deeds and whether there is a earlier partition or not, all these issues have to be decided by the court during the course of trial, and at the threshold in an injunction petition, all these things cannot be all these things the court ought not to have gone into. It is submitted that the court was referring to a suit of 2017 in that he is not a party and it is the one of the defendants have filed and the same is not binding on the plaintiff. It is submitted that the court below ought to have allowed the court initially had granted an ex parte interim injunction. Thereafter, on contest by the defendants, the same is vacated. It is submitted that the IA needs to be allowed. Anything else?
We are not the party to 1956.
That I've already recorded.
1950 partition did.
How can you be by the
Birth
time?
ಆಗಿರಲ್ಲ.
Huh?
No birth of fathers only.
Their fathers also, not.
You are not saying about, there is no partition according to you.
Yes, madam.
That is what is your bone of
Now
contention.
they are producing 1956 partition day. That
No,
means-
this court is not giving any finding. I have not looked at the
Therefore,
partition.
I'm not find an application for amendment.
We will not look into all that. This is not the stage. This is an interlocutory application.
Court
What
is-
is before the court, that only we will look into. We shouldn't expand the scope of the petition itself. The land counsel appearing for the councils, the council appearing for the defendants 9 to 14 and defendant number 20 have submitted that. You are sailing together.
No, no,
Uh.
no. I am on together on my own footing. He appear for defendant. He
Defendant.
is adapted my statement.
That's what I'm
Yes,
saying.
yes,
You
yes,
are
yes.
you are on the similar
Yes.
lines.
Yes, yes.
The land council appearing for defendant number
20.
9 to 14 and defendant number 20 have argued in the similar lines. It is submitted that there is a earlier partition of 1956. And basing on that, the revenue entries were made in the year 1974.
71.
And in the year 1971, and thereafter, they are enjoying their respective shares. It is their case that, in fact, the plaintiff had sold some of the properties, that particular aspect was brought to the notice of the court, and they have also filed the registered extract of those sale deeds. Considering all that, the court has come to a right conclusion and felt that the plaintiff had not disclosed all the facts before the court and he is not entitled for the equitable relief of injunction. It is submitted that the defendants 9 to 14, in fact, have the leased out the lands which are, you are there. The plaintiff.
Along with some other defendant.
Contention. It is a contention of the defendant that the plaintiff had leased out some of the properties of the joint family, which are the scheduled properties, as mentioned in this, not the joint family properties. The
Their share.
plaintiff had leased out the properties, which are shown as joint family properties, as as the scheduled properties, which fell to his share as per the earlier partition, and he is even receiving. He has let it on lease and he is also receiving huge amounts as lease on a monthly basis. It is submitted that the suppressing all these facts, the plaintiff had approached the court and the court had rightly dismissed the petition. And there are no grounds to interfere with the well-considered order passed by the court. Next, having heard the land counsels on either side, peruse the material on record. The plaintiff had filed a suit for injunction, that is in respect of 69 properties, 9 properties measuring an extent of 200 acres and odd. The age of the plaintiff himself is
62.
the age of the plaintiff himself is 62 years. According to him, the entire property belongs to his great-grandfather. And right from the great-grandfather's time till now, the property is in the joint, property is in there was never a partition and they have been enjoying the property in the status of members of a joint family, undivided Hindu joint family. It is his case that now when he asked for the partition, the respondents have refused, as such has come up with the suit for partition, seeking 1/36th share.
But the prayer, my lord, only 1/4 of their 1/4.
That is 1/36 share.
136.
1/36 share of the suit.
It will not come 136, not.
136.
That is what you said so. The court has observed that is 1/36 share.
1/4 share to the plaintiff in their father's share.
Their claim.
So 1/4 of each son, my lord, of Youngtappa. I will take my lord.
1/4 share of the plaintiff to their father. The court has calculated everything
Whole.
and come to that is
Propositors
what,
share. my lord.
it comes to 1/36.
Probably it's wrong.
That is in the order. That what did you write
36.
before that? One by 36 share in the property, and is his apprehension that the defendants are selling away the property. The plaint, this court has perused the plaint. Plaint runs into the cause title runs into 4 pages, and the plaint into 4 pages, and the remaining is the suit schedule properties. Except, as rightly observed by the court, except stating about that it is a joint family property and it is not partitioned. He has not mentioned about when there are so many properties about what are the revenue entries, how are they, in whose name that is standing, if it is standing, why it is standing. None of the details were disclosed in the plaint. When the defendants have entered appearance, they have stated about some of the sale leads executed by the defendants. When an injunction is, when a suit for injunction is filed, when an interim injunction, suit for partition, and when he has filed an application for injunction, he has to, which is an equitable relief. The party has to come before the court with all the relevant facts, and there should not be any suppression of facts. That particular sale deeds which are executed by him, if it is his case that the suit schedule properties or the joint family properties, then without the partition, the member of the joint family will not get any right to execute a sale deed. If such a sale deed is executed, why it was executed, nothing has been stated by the plaintiff. It has come to light after the defendants have filed their written statement. As rightly observed by the court, he is seeking 1/36 share in the properties. Considering the fact that the plaintiff himself is above 60 years old, and he is referring to, he is a great grandson of the Venkatappa, whose property, according to him, the property belongs. And without any disclosure about all these properties in whose name the mutation is done, the court cannot grant injunction. While the granting injunction in favor of granting injunction, the court has to look at the prima facie case, balance of convenience, and irreparable loss. A small part of the extent which he might, if in the event the suit, if he is successful in the suit, a small part of the land, parcel of it is entitled. For that, the entire extent of 200 acres and odd, there cannot be any stay of alienation. And particularly in these facts and circumstances of the case, where the defendants plead that there is a prior partition, and also they are relying on some of the sale deeds. In that view of the matter, and in the event, if the court comes to the conclusion that is entitled for partition, if the properties are sold, then that is hit by lis pendency, and the court below has rightly dealt with the application, and this court finds no reasons to interfere. You are appearing for defendants?
Or 1, 2, 6, 7, 8, and or 16 to 19.
The defendants who were set ex parte before the court below, learned counsel appearing for them before this court submits that he is supporting the case of the plaintiff.
This order.
No partition had taken place.
This order may not be affected.
This, any of the observations made by this court in this order are only for the limited purpose of disposing of this interlocutory application. And any of the observations of this court may not be considered. The court below shall not consider the same as expression of this court and shall decide the suit on the merits of it. Yes.
Great, my lord. Much obliged.
Post number 16. Prabhakar for appellant.
In this case, my lords, I have complied with the directions of the court, my lord, to come supply the copies, my lord. Twice I have done it.
Argue.
Yes.
I have
my
received the copy.
Yes, yes.
lord, sir. The plaintiff here before your lords, my lord, sir, this is plaintiff's appeal, filed a suit for permanent injunction, stating that the neighboring owner, who is none other than his sister, who has got that property in a partition along with this plaintiff's wife, there is a passage of 2 feet that which have left by the plaintiff. The defendants are putting up construction, encroaching upon my 2 feet property also. They are not leaving 1 inch of setback. I am not on setback. I am on my 2 feet. I filed a suit. I lodged a complaint before the BBMP. BBMP also did not take any action. After the interim order passed by this honorable court, now they have issued a notice to demolish the illegal construction. That's separate, my lords. Now, in this suit, I have pleaded that this 2 feet by 52 feet, which I have left, and the pipelines are running. I have produced the photographs, my lords. And I pleaded before the court that let them construct even without leaving setback also, we are not worried. Let them not encroach upon my property and damage the drainage pipes, which they have done it, which I have shown through the photographs to
Let's see that. Please come to the order.
Yes, my lord.
Where is the order?
Yes, your lordship may kindly.
13?
13 order sheet, 14 is the.
Yes.
May read order, my lord. Peruse plaintiff government's documents produced, IA number 1 and the annexed affidavit. Plaintiff instituted the suit against defendant seeking for the relief of permanent injunction. Plaintiff through IA number 1 seeking ad interim ex parte temporary injunction against defendants, the agent so and so on behalf of restraining them from interfering or putting up any construction over the Schedule B property, which is my property, which prevents the free flow of air and light to the Schedule
Where are
A
you
property in any manner.
Where are you reading?
I am reading page number 14.
But I don't find all that in page number 14.
My lords, that is document number 1, my lords. It's, I may be sorry, page number may be some different.
No, it starts with page number 12.
12, 13, my lord, then.
No.
13.
Order on IA.
Yes, yes, orders on IA.
That is your prayer. This page is prayer.
No, no, my lord, this is the order.
No. What is in that order? Your
Yeah.
prayer is extracted.
Yes, yes. Next page, my lord.
That 4 lines is order.
Yes, yes, my lord. Next page, my lords. At this stage, plaintiff not established prima facie case against the defendants as the defendants are the adjacent owners of the suited property and they are constructing the building in their property. Hence, the court finds that without hearing the defendants, it is not just and proper to pass any interim order. Therefore, I proceed to pass the following. Issue emergent notice, my lords. Without application of mine, I am saying that Schedule B property is my left setback.
But by this time you would have come, the court would have heard it.
But they could have completed, they could have damaged. The lordship may kindly see the photograph.
Yes, what do you say? What is happening?
But that's the thing is, the 2 schedules which the learned counsel is talking about is not there. First of all, Schedule A property is the entire property. He is telling that there is a Schedule B property 2 into 52 feet. That is not there. So as per the decree, I am his sister's son basically. I started the construction. I have completed 2 floors. I have started residing there also. After that, this particular dispute arises. And what he is saying is, I need to also leave 2 feet. And he has given a complaint to the BBMP also. I am not constructing in his property. I undertake also that I have not constructed in his property. Let the
Will,
commissioner be
will
appointed
the
before
court
the
is
lower court?
undertaking that he will not, they will not construct in your two, whatever is
Yes.
the disputed.
Yes,
We will record that.
they have demolished. If it photographs is clear. Your Lordship.
You
yes.
is, where is the
Demolition or
2
whatever
feet,
it is, it has to be done before the lower court itself, my lords. What has happened?
And my
There is
2
no
feet is
order
encroached.
passed
They are trying to encroach upon
on
my 2
IA
feet.
number 1.
Your Lordship may kindly see all my,
No, where will the court understand about this 2 feet from this photographs?
my lords, the portion which water is flowing, my lords. That is, they have broken the pipes.
My lords, I am constructing in
your
my
house?
property itself.
Where is your house?
My house is adjacent to it, my lords.
ಅಲ್ಲಿ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ನಡಿಬೇಕಾದ್ರೆ ಅಲ್ಲಿ ನೀರ್ ಹೋಗ್ತಾ ಇರೋ ಫೋಟೋಗಳನ್ನ ತೋರಿಸ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ. ದಟ್ ಇಸ್ ನಾಟ್ ಗೋಯಿಂಗ್ ಟು ವರ್ಕ್.
What are you saying?
What they are showing is the water which was flowing during the time of construction. Now the construction is completed also, and I am residing in that property itself right now. They cannot deny that also. Before they got the injunction order from this honorable court, we have started residing in this property itself.
In
Family
violation
members,
of the interim
it may
order
be sent
saying that
back
they
to
have
the
not
court.
received, they
Some
have been
15 days,
constructing. I'll file a
15 days
contempt
time
also.
may be granted. We will dispose of the IA itself. I am not objecting on that. I am constructing on my property. If that has to be concluded, then the court commissioner has to be appointed.
1 minute, this court cannot consider all this. What is this photographs? First of all, where are both your houses? Where is the construction? Whether he is doing construction in
Yeah,
his
yes.
house or not in, now
I have
he
produced-
says that, now will record his undertaking that they will not make any construction in your 2 feet land.
Yes, my lord.
At least you believe, you accept that there is a 2 feet land.
I
in
am
between.
accepting, ಆ ಜಾಗದಲ್ಲಿ ನಾನು ಕನ್ಸ್ಟ್ರಕ್ಷನ್
Then we will
ಮಾಡ್ತಾ ಇಲ್ಲ.
record-
My entire suit is that.
No, we'll record that.
Yes, my lords.
We'll record that and let the court.
Let the court
final-
decide within 30 days. my
Yes.
lords.
The petitioner, agreed with the orders passed in I number 1 in OS number 3165/2024 dated, what is the date of order?
27.
27/4/2024, whereby the court below, whereby the trial court had dismissed his application for
Not
injunction.
dismissed.
It's not dismissed, ma'am. Only emergent notice was issued.
Is application in the app, in an IA seeking injunction, court has issued emergent notice to the defendant. The petitioner has come before this court, the appellant is before this court. This court, when on the court on 9/5/2024 had pending consideration of I number 1 of 2024 has restrained the respondent defendants from putting up any construction and damaging the pipelines in the Schedule B property till the next date of hearing. It is the case of the petitioner that in spite of an order, they have damaged the pipelines. It is the case of the appellant plaintiff that in spite of an order, they have damaged the pipelines. It is the relief that is sought in the suit is, where is the plaint?
The plaint is at page number 15 minutes, document number 2. And the operative portion of the schedule description is at page number 23.
The relief that is sought in the plaint is granting a permanent injunction restraining the defendants from interfering or putting up any construction or the school or the suit P procedural property and preventing free flow of air and light to the Schedule A property. It is the case of the plaintiff that the defendant is none other than his sister.
Sister. First defendant is sister.
It is this case that plaint A property is a part of larger extent of old property bearing number 527. and the property was divided into 3 portions under a final decree, invoice number 4565 of 1998, by judgment and decree dated 3/12/1988. Under the said decree, item number 1 of the property has been allotted in favor of the second defendant in the suit. And item number 2 of the property is allotted in favor of the plaintiff. And the item number 3 of the property has been allotted in favor of another sister,
Yes, my lords.
in
There are
favor
two
of another
sisters.
sister.
That is,
The
Leelavati is one sister,
Hmm.
Mahalakshmi is the second
Yes.
sister.
It is the case that the ARO upon spot inspection and verification of the document has accorded permission and bifurcated the property by assigning separate municipal numbers to the respective shares. And the plaintiff was assigned with municipal number 30/1 and retained the old number 527 of 30 insofar as the property fallen to the share of the first defendant by order dated 23/11/1995. And the plaintiff is scheduled property. A building was constructed. And they have been paying taxes to the BBMP. It is their case that at the time of constructing the building, they have left 2 into 53 feet setback on the southern side of the property for free flow of air and light. The defendant's property is situated after the passage of 2 into 53 feet by the plaintiff, which is described as Schedule B property. It is a case of the plaintiff that now the defendants are putting up new construction over their property, over their property, and in that process, they're also making construction in the 2 feet, which that is a suit B
encroaching
scheduled
plaintiff.
property, encroaching the suit B scheduled property without leaving setback as per the sanctioned plan on the southern side of the Schedule A property. It is stated that the construction that is carried out by the defendants is not only against the sanctioned plan and license, but also encroaching the land of the plaintiff. They have damaged the pipeline of the drainage water and sanitary pipes, which is meant for free flow by the plaintiff. In spite of the request made by the plaintiff, the defendants carried on with the said construction, and also he gave a complaint to the BBMP on 9/4/2024 regarding regarding the construction that is made by the defendants contrary to the sanctioned plan and plan. In the said suit, is filed with he came up with an IA seeking injunction restraining them from damaging the said suit Schedule B property and property. The court, by ordering, the court had issued notice, emergent notice to the defendants. Agreed thereby, the plaintiff has come before this court. Land counsel appearing for the petitioner appellant plaintiff submits that unless the court, without looking at the urgency and also the prima facie case being made out by the plaintiff, still has without granting injunction, as it should notice to the defendant in the, the court has failed to consider the irreparable loss and injury to the plaintiff. And also the observation of the court that the prima facie case is not made out and issuing as such emergent notice is issued is also without any basis. He submits that after he approached this court has granted injunction. In spite of an order of injunction, he has proceeded with the construction. He has damaged the pipeline and pipeline, full stop. The complaint which is given by him to the BBMP was also considered, and now they have issued a notice to the defendants to remove the illegal construction. Land Council submits that he is not concerned with the illegal construction, but he is concerned only with the encroachment of the Schedule B property and making constructions and damaging the pipeline, and also obstructing the free flow of air to the plaintiff. Land Council and the Land Council appearing for the defendant submits that in fact they have not made any construction in that suit B schedule property, and they have never interfered, they have never encroached the said land. The photographs that are filed saying that the petition has violated, the respondent has violated the orders of the court is without any basis. He submits that they also do admit that there is a 2 feet.
2 into 53.
2 into 53 minutes. What has happened? The 2 into
There is a,
53. Yes.
about the existence of the B schedule property. And
There is space, not exactly 2 feet, it is 1.5 feet. So there is a dispute with respect to that also. So what we are saying is the area of space which has been left out is by me. So that is the problem.
They do accept that there is a gap between the two houses, but with regard to what is the exact length, the measurement of that,
Measurement, yes.
there is a dispute. According to the plaintiff, it is 2 into 53. According to the defendant, it is
1.5.
1 to 1.5 feet minutes, which is left by me. That is what I am saying.
1 to 1.5 feet. He submits that. Now, pending disposal of the suit, as far as that B schedule property is concerned, they will not make any constructions or interfere with the. They will not make any construction and their construction. Considering next, having got the councils on either side.
Construction on the B schedule property minutes.
That's
B
what.
schedule, that's it.
Yes.
Considering the submission of the learned counsel for the defendant that as far as the schedule B, the B schedule property is concerned, they will not make, they'll not interfere or make any construction. And also the fact that it has to be adjudicated by the court, whether that, what is the width of the said property, B schedule property. Accordingly, recording the submission of the land council.
Well, it's one submission minutes. What is the width and also to whom that particular property belongs? Because I am stating that I will take that property.
To whom it belongs to has to be adjudicated by the court. However, till the pendency of the suit, there shall be an injunction restraining the defendant from interfering with the suit B schedule property
Much.
disposed of. Yes, next.
Cell number 17.
I appear for the appellant, madam. Kindly pass over.
Your Lordship, due to some inconvenience, senior is not available. If it's okay, it may be taken up tomorrow, Your Ladyship.
Not tomorrow, we'll have it on Tuesday. Post this matter on Tuesday, the request of land council for the.
Next week, senior is not.
Huh?
Next week, he might not be available. Any date after that.
What is this? How can it be? I can understand one day. Today, she is not in, it is inconvenient to her. Monday, it is inconvenient to you.
Might be convenient.
Huh?
Any date next week.
Next Friday, Your Lordship, if it's okay.
Matters will be listed, not every day on your convenience. It should come up on,
Yes.
it will come up on Tuesday.
Wait.
Yes.
Cell number 17. Change 18. Venkatesh.
I appear for appellant in this case, Your Lordship. This is in this case, the May I take your lordship to the
Photographs. Here it is. Yes.
Your lordship, in this case, respondent number 1 and 2 are the plaintiff. And the appellant here is the third defendant in the plaintiff, your lordship. In this case, your lordship, the first and second first and second respondent, that is plaintiff here, is filed a suit for partition. Your lordship, in this, may I take your lordship to the partition deed as at page number 83, your lordship.
You are the member of the joint family.
No, I am the purchaser of the only unit. There's a large extent of property. Out of that, only one unit.
You purchased, when did you purchase?
I purchased in 2022, your lordship.
From whom you purchased?
No, from the second respondent, that is the fourth respondent.
Fourth defendant.
Fourth defendant. No, here for the defendant.
From in the suit.
In the suit from the second defendant. Your lordship, kindly appreciate. The first defendant is the joint family member, the first defendant. He had sold one unit to the second defendant in 2013.
Second defendant is also part of the joint.
He is also the third party. He is a stranger. He purchased in 2013. He mortgaged to Central SBI. And the charge was subsisting till 2022. I purchased the property when it was under charge, your lordship. May I request your lord, the case of this only the collusion suit, your lordship, this collusion suit. May I request your lordship to page number 83. One Muniyallappa was the original owner, your lordship. Page number 83 is the partition, your lordship. Before that, may I beg your lordship?
No, even before you go to that, please come to the order, then you can make your submission.
No,
it's more clear to the court.
No, the issue is that, your lordship, the large extent of property was allotted.
1 minute. Which case? But for admission, it's coming. Yes.
Your lordship, the large extent of property was allotted to Muniyallappa. Muniyallappa gifted one property that is measuring 2,500 square feet to first defendant Ramaswamy. Only one. In that, Ramaswamy constructed an apartment comprising of 15 units. Out of that 15 units, only one unit has been sold to second defendant in 2013. In 2022, I purchased that unit. Kindly come to suit schedule property, your lordship. I beg your lordship to suit. Only with respect to that property, they have filed a partition suit. May I beg your lordship, I have produced the plain copy also, your lordship. That is at 94. Page number 94.
What is the injunction that is sought?
Injunction not to alienate the property, your lordship. And then not property or
please tell the court, where is the plaint? Let us see the plaint. What are the...
Page 94, your lordship. Page 94. Your lordship got it?
1 minute.
Next year, M, your lordship. Lordship, schedule is at page number 98.
This is the only property.
Only one unit they have claimed, which I have purchased.
For only this, they want partition.
Yes, your lord, for this unit. Out of that, they only say there are 50.
Let us see the averment in the plaint.
May I request you, that is plaint, your lord. The lordship, kindly see. Para 3 is the description. 3. All that piece and parcel of the residential flat number 5 in the first floor of residential building known as BMS Delights, ward number so and so, measuring 1,100 square feet. May request para 5, your lordship. Sri Muniyallappa have 3 children. They are the plaintiffs and defendant. The copy of the family tree is produced at so and so. That as per the Panchayat dated 31/3/92, the scheduled properties were fallen to the share of Muniyallappa, and from the date of above Panchayat, our father is in physical possession, enjoyment of the suit scheduled property, and all the revenue records stands in the name of Muniyallappa. So the defendant number 1 is the elder brother of the plaintiffs. Between age of defendants and the plaintiff is difference of 14 to 15 years, and the plaintiff number 2 having marriage a long back and residing with her husband in the above mentioned address. Having taken to the advantage of this defendant fraudulently taken the suit to his name through executing a gift deed from our father. The gift deed is 2004. that till now the execution of gift deed to the name of the defendant from our father is known.
It's in respect of the whole premises.
Gift deed is it with respect to that item number 1 of that Panchayat Parikat which had happened in 1992, Your Lordship.
No, that's what I'm saying. You say that one building is constructed in this. In
Yes,
that you have purchased one apartment.
One unit.
One unit you have purchased.
Yes, Your Lord.
So now this gift deed is referring to the entire 15 units.
Entire 15 units.
Yes.
And gift deed. The taking advantage of fraudulent gift deed, defendant is constructing, number 1, constructing apartment residential flats in the scheduled property without initiating intimating the plaintiffs and his father. On 23/11/13, defendant number 1 has been sell the C scheduled property to the second defendant for a meager sale of consideration of 37 lakhs and so and so. Once again on 12/8/22, defendant number 1 had sell the C scheduled property to the defendant number for a meager sale consideration of 31 lakhs, Your Lordship. That in the month of September 22.
Please come to the schedule of the properties.
Pardon, Your Lordship.
Please come to the schedule of the properties. Page number 98.
98. Yes, 98, Your Lordship. Only schedule A property, A property is the entire property. And the schedule be 250 square feet in schedule A property. That is only 1/10 of that whole property. That is only claiming on schedule C property. The partition is claimed in schedule C property.
In respect of apartment flat number 5 in the first floor.
Yes, Your Lord. That's the only unit they are claiming, Your Lord.
There are 15 units.
Yes, Your Lord.
You purchase C or
only one unit.
C.
That is the B and C. B and C. C is the apartment area. B is the undivided share in land. Undivided share in land is B, Your Lordship. And C is the unit.
No, I'm not able to understand one thing in this. In respect of the entire building, they sought for partition.
Yes, no. They sought for partition only with respect to schedule C property, B and C.
What is schedule A?
A is the entire property.
Then
may I request Your Lordship to pay the prayers.
No, if you say schedule A is
Yes.
the entire property.
Yes,
That
Your
means
Lordship.
entire building would come.
Building would come down.
Then
But the sale is with respect to me only. That's only one unit has been
there's
sold.
only one unit is sold.
Sold to me. And the injunction is sought only with respect to that particular unit.
No, for the remaining thing, there is nothing.
We are no way concerned, Your Lordship. We are no way concerned, Your Lordship.
So what is wrong in it? Not to further alienate?
No, with respect to schedule C property only, Your Lordship. Only with respect to schedule C property. May I beg, for that reason, I request Your Lordship to page number 83. For a moment, Your Lordship. For a moment, Your Lordship.
Notice.
No, for a moment, you kindly come.
No, we will dispose it off finally. Take out notice.
With the dispose of, with the direction to.
No. Let the other side come. Notice go. Once they come, we'll pass a final order.
May I beg only one submission. May I request Your Lordship to page number 83.
No,
Only one submission, one humble submission.
Yes.
83. Okay, in that, this is the entire partition, Your Lordship. Your Lordship got it? 83. Panchayat family partition.
Yes.
Kindly come to page number 88, Your Lordship. Schedule C. 88.
Yes.
Your Lordship, schedule C. This is Muniyallappa. Your Lordship got it? Item now 1, 2, 3, 4. These are the 4 items was allotted to the father of plaintiffs and first defendant. But this item number 1 is the particular property in which the schedule apartment has come up. So they are not claiming on any all the 4 properties. 1, 2, 3, 4 here. And Muniyallappa, the father of the plaintiff and first is still alive. He has not made a party because have only the unit which has been.
That's why I understood your contentions. Please take out notice on the counsel appearing before the trial court for the respondent.
Only with respect to first and second, but that the plaintiffs you are also. Between third and fourth, third respondent is the first. He has filed only wakalat, not filed written statement, and the fourth.
You say that they are not necessary parties to this petition and file a memo to that effect. Then we'll dispense with.
No, what I'm submitting, Your Lordship, they are not filed because there is a collusion. So that's what I'm trying to say.
You can file a memo, whatever you want. Otherwise, notice has to go. If you say notice is not required, we'll record that.
Let the notice, because the problem is that they'll intentionally they avoid and they will not come. That is the reason I'm.
Just do that. The petition is permitted to take out notice on the counsel appearing for the respondent before the trial court. We shall file a memo. Appellant shall file a memo to that effect. Registry is directed to issue notice. When can you?
We have hand summons to the.
Shall permitted to take hand summons
to the counsel for the
respondent.
Respondents,
Pose this matter on, when can you take? Shall it be on 13th of August?
much obliged.
13th of August, yes.
Number 19 to 21 adjourned, 22, Shivraju.
Serial number 20, it's not urgent, you know.
Hmm.
Serial number 20, it's not urgent.
20 is not adjourned.
No, 20 is not urgent. Yeah, we have been waiting here, I don't know.
Huh? 19, not 19 and 20, 19, 21. Yes,
20.
yes.
Great. This appeal is by the plaintiff.
Yes.
The application was filed for temporary injunction in
Hmm.
the suit filed by the plaintiff. The suit was filed by the plaintiff on, say, the main ground is that the plaintiff is the owner of 2 flats in an apartment. That is 2009 and 409. The grievance of the plaintiffs before the court below was that the defendant number 1 association called Welfare Association, they are collecting the maintenance fee, etc. So far as the apartments are concerned, including the flats purchased by the plaintiffs. So therefore, plaintiffs claimed on main ground saying that you are an association, you ought to have been registered under the 1972 Act, Apartment Development Act. But your association registered under the Karnataka Societies Registration Act 1960, which is not permissible, as held by the Honorable Court in the decision of the division bench of the Honorable Court. Those documents were made available, showing that the defendant number 1 association was registered under the Karnataka Societies Registration Act 1960, not under the Apartment Act 1972. But now, see, our request for grant of temporary injunction, see, our prayer, your last kindly see, the prayer in the suit, we have produced the plain copy also. So our prayer was, one is restraining the defendants from collecting monthly maintenance from all the flat owners, occupants residing at Mahavir Boyer, as it is contrary to the provisions of the Karnataka Societies Cooperative Society Act 1960. It must be Karnataka Registration Societies Act. And then another prayer is judgment and decree in the nature of the permanent injunction against the defendant number 7 from putting up any further construction, the schedule B, and restrain defendant number 2 to 6 permanently by way of mandatory injunction from being from doing any kind of transactions with respond.
What is this fee schedule?
B schedule is apartment, say C apartment in which I don't have flat at all, but it is adjacent to my flat and it is being demolished now. Without any consent of the residents, they have taken the action through the other defendants for the purpose of demolishing and reconstruction of the same. While doing so, the covenants are, they will have to take consent of the residents, which they have not done it. So this has caused a nuisance so far as the residents are concerned. Therefore, that second prayer is added. So my response submission is, you last may kindly see, now the court below has passed the order of emergent notice denying the temporary injunction. If the temporary injunction is not granted, they will have to see undergo the embarrass.
No, number 1, the relief that you're seeking is
Please.
the injunction that is that they
Defendant
should
number
not
1.
collect the money. If nobody collects the money, nobody maintains the apartment, what would happen? Somebody has to collect the money, somebody has to, or else the court has to say that so-and-so in a separate account, this should be, just like that, there can't be any injunction unless the other side comes. So what has been happening now with the emergent notice, nothing much is no, I mean, injustice won't happen to you.
Question is, otherwise we would not have filed it. In fact, we have filed a petition also before the concerned authority saying that this association is illegal, which cannot act according to the registration certificate issued now. That is also pending. Exhausting all the remedies, we came to this honorable court. Right? So what has happened is, the question is, so whether I have made out the prima facie case or not. See, the claim, the defendant making the claim on what basis?
You are one individual. You are one individual.
I am the
There are
flat
so
owner.
many people in the apartment.
I am the
So-
flat owner of 2 flats
Two flat, you're
in an
correct.
apartment.
No, this, when did you buy the apartment? When are you, from how long you're residing?
Yes.
From how long? When was the apartment purchased by you?
Blood, this was in 2000, say, 4, 5.
2005.
4, 5, yes.
And now the suit is filed in the year 20? Which year is the suit?
2024. Till then, we were making the request representation before the registrar also we approached, exhausted all the remedies, saying that de-recognize that to say association. That is also a matter pending. We did not keep quiet at all.
When is the matter posted before the court? Emergent notice when, where is sir?
And see, the matter is now listed on day after tomorrow. That is on 3/8, if I am right.
Let the court decide it. Let the
Please.
court decide it. This is not a case where when something is happening from.
I understand, but only one question you will ask me, kindly appreciate. The claim by the respondent number 1, indisputably depending upon the registration certificate, which is not permissible in the eye of law, as held by this honorable court. You will ask me kindly see for a moment. I will not trouble
No,
much.
we'll accept that proposition that that is not.
Ah, yes. So therefore, Millet, they have no stand at all. They have no local stand even to demand, make a demand. But that is being done. Despite our say requisition, despite our representation, despite our say showing the flaw in the association registration, etc. So that is being continued for a long time. How long we can tolerate all these things? So
We'll ask the court
so
below
such
to
being the
decide it
case-
on the next date of hearing when the defendant also appears, not an ex parte order in this, where you're just a part of an apartment and the reliefs that you sought is that should not be demolished and they should not collect their rent, then what will happen to the apartment? Who will
can
do it?
understand, Millet.
It is a larger picture.
Millet, I truly appreciate the opinion of this honorable court, Millet. So, but question is illegal. Illegally they are doing it.
They're doing it from 2004.
Doesn't matter.
That
We
will be
can't-
another, once the notice is given, they will, the court will consider it.
2004, I did not keep quiet. What I am submitting is from 2004 onwards.
You have been pursuing it.
Yeah.
But the fact remains is till 2024, till now, nothing has happened. No, when you're asking for an ad interim injunction, this is not a case for ad interim injunction. Let the defendant also come. The court will have all the complete picture before it. And then the court will pass the same order.
My response submission, document was before the court.
I can understand it is about your own case. It is not about your own case. It is about the entire apartment.
Maybe, Milad, so far my rights are concerned, Milad, see, just because the others have not come to the court, Milad, I cannot say suffer. See,
No, the court has also.
I can understand, Milad, in any other situation, I will have to undergo the emergent notice and but here is a case where in unauthorized association, I should use the word, an unauthorized association making the demand, and which I have brought it to the notice of this honorable court, there is no dispute that aspect is concerned. Under those circumstances, my submission is, before hearing the defendants, what is wrong in it? How long I can continue when my rights are, say, under threat? This is my response submission, Milad. And Milad, one another aspect is, Milad. So there, see, construction is going on. It is causing a lot of nuisance and it is hurting the residents also, Milad, in several ways. Under these circumstances, at least, see, status quo would have been all right. Status quo would have been all right. Till the next date of hearing or till the defendants comes before this honorable court or the trial court and hear them. So that is how I distinguish. See, I distinguish. There is, I understand that. So till the defendants appears, the emergent notice can be issued in so many cases. But here is a case where we have made out saying that where there is no, let us say, association registered according to
when contrary to something, if they are demolishing it, then you could have gone to the municipality also.
Sir,
They are the right people to do it.
So in this case, we have brought it to the notice of all the authorities, but we were not able to get any relief at all. Having no alternative, we had approached this.
Please come.
Kindly consider the situation in which I am placed now.
Agreed with the present writ petition is filed. Agreed by the issuing of a emergent notice to the defendant without granting injunction as interim injunction as paid for by the plaintiff. The petitioner herein is the plaintiff in the suit. He has filed the suit seeking a mandatory injunction against the defendant association, restraining them from collecting monthly maintenance from all the flat owners, occupant residing at Mahavir Bower with inverted commas, as it is contrary to the provisions of the Karnataka Cooperative Societies Act and also a judgment and decree in the nature of permanent injunction against defendant number 7.
Sorry if I am not interrupting, only one submission. Till the disposal of the IA, at least your last may kindly direct the defendant number 1 not to make any demand.
Not to make any
Demand
the.
till the disposal of IA.
Defendant number 7 from putting up any further construction in scheduled property B and restrain defendant number 2 to 6 permanently by way of mandatory injunction from doing any kind of transaction with respect to schedule B property permanently. In that, IN number 1 is filed seeking injunction.
And the reasoning is also not sound reasoning.
Yes. The IN number, where is that IN number 1?
IA number 1 along with the appeal memo at page
Along with
37
that, an IA is filed stating
37.
that the petitioner is a bona fide purchaser of flat bearing number 209 in first floor, block A, and flat bearing number 409 in third floor. He had purchased these properties in the year 2004. The association is registered in the Cooperative Societies Act, which is not permissible. And it
No,
is,
it is registered under the Karnataka Societies Registration Act, not cooperative.
sir, it is registered under,
Karnataka Societies Registration Act 1960.
it is registered under.
Registered under that act, which is not
Ah,
permissible.
so
That's
this-
what this honorable court has held.
It is registered in the Karnataka Societies Act,
Karnataka Societies Registration Act
Societies
1960.
Registration Act 1960, which is contrary to the law laid down by this court, by a division bench of this court. It is their case that,
In the division bench.
it is their case
So,
that they have
please,
some serious objections
Will
stated.
you please?
They have
kind-
some serious objections with respect to the handling of the accounts. And this, and the same is pending consideration before the appropriate authority.
Relevant para is 9.
They had registered under any, they have not registered under specific law. And they're collecting the maintenance from the owners of the flat, which is against law. The office bearers colluded with each other and are demolishing the entire block C by throwing the law in air and without any prior approval from the competent authority. The constructor who had demolished the building now has started to construct the structure without there being any proper approval in terms of statutory clearance, which is in clear violation of law. The petitioner, the appellant herein had raised concerns with, in this respect and had lodged a complaint with the jurisdictional police station, brought it to the attention of the BBMP, and so far no action has been taken. Hence, they sought for an injunction restraining the defendants from collecting the maintenance fee from the flat owners and putting up any further construction in blocks C by way of injunction. The trial court had issued the court by order dated that is 11/7/2024, has observed that that at this stage, the court is not inclined to pass an order. And after hearing the defendants, the order can be passed.
It is at page 13 minutes. 1-3.
Yes. The court is inclined to hear the defendants before passing an order. Agreed thereby, the plaintiff is before this court. Learned senior counsel appearing for the plaintiff, petitioner appellant plaintiff submits that a division bench of this court in writ appeal number 974 of 2009 and batch by order dated 6th November 2019 has laid down the law that
Relevant para 9.
the apartment has to be registered as per the provisions of what is the act?
Karnataka Apartment Ownership Act 1972.
Karnataka Apartment Ownership Act 1972, but not the Society Registration Act. Basing on this judgment, then a senior counsel submits that on the face of it, the defendant association is registered under the Karnataka Registration Act, and the same that itself is an illegality, and they cannot be permitted to collect the rent, collect the maintenance. It is submitted that now they are illegally demolishing the C block without the permission of the residents of the apartment, and also without obtaining any statutory permissions. The trial court ought to have granted injunction and considering the illegality that is being committed by the defendant association. The court, without considering all these aspects, has simply issued notice to the defendant. This is a fit case where an ad interim injunction has to be granted, or else irreparable loss and hardship would be caused to the plaintiff. Anything else to be recorded? Anything else to be recorded?
That's all.
This court, having heard the learned senior counsel, had perused the entire material placed before this court. The suit is, the injunction that is sought is against the Apartments Association, which is registered contrary to the provisions of law. It is the contention of the senior counsel that as the association that is formed is in a blatant violation of the law, and they are not permitted to collect the maintenance from the flat owners.
They have no authority according to.
Authority, as they have no authority, as such, they cannot collect the maintenance from the flat owners. And also with regard to the other prayer that is not to demolish the C block. Now, the court has ordered a notice to the defendant. This is a case where the apartments were constructed way back, and the petitioner himself, the appellant himself, is staying in the apartment right from the year 2004. If as sought by the petitioner appellant without even a notice to the defendant, the court cannot direct the apartment or the association not to collect any money from the occupants. And also there cannot be any injunction restraining from making any construction in respect of the B scheduled property, as the court, that there should be the necessary material is not before the court. And this is not a case that if a short notice is, if an emergent notice is given and a short accommodation is made, that there would be an irreparable loss which cannot be compensated to the plaintiff. An order, once the court hears both the parties, as it is not pertaining to the plaintiff alone, but there are other occupants in the apartment. And if an order of restraining them from collecting, and if they are stopped from maintaining the apartment, who else has to do? And all these are the issues German for consideration before granting an injunction. Hence, in the considered opinion of this court, the court was right in issuing emergent notice, and also that before passing an order, the court wants to hear the defendant. This is not a case where an ex parte injunction can be granted, and it is submitted that the matter is coming up before the court after tomorrow. The court should make the court shall hear the defendant and shall pass orders on this application
Expeditious.
as expeditiously as possible without further delay. Yes.
Hmm? Till then, let them not make it.
Had it been a case, I would have done it even without you asking it. Appeal disposed.
My lord, period number 43, my lord.
40?
43.
Huh.
Petitioner tries to withdraw the said petition because it is compromised before the trial court. With respect
You're
to-
filing a memo?
I file a memo.
Please pass on. The memo is filed stating that the matter is compromised before the family court by order dated 13/8/2022. Hence, this petition do not survive for consideration, accordingly dismissed as withdrawn.
Number 38. Serial number 38.
Only the people who want to withdraw and give one more disposal to the court, 130 for them, not for any, for other adjournments.
Great.
Hello.
Then all the more reason that you shouldn't ask. No,
Not on the spot, because not when all these people, not when I
Hmm.
was putting up a compound wall, not these people came to the spot, not and started erecting a board saying that this is my property, but giving a different description of the very same property, different number, different measurement, everything.
that is one, not to alienate is one. Two is not to interfere.
Not to.
What did the court say?
Not court says there are two sets of documents that has to be determined only in the course of trial. At this stage, no injunction can be.
Hmm.
Court does not disbelieve the documents of the plaintiffs.
Let's see
Court-
the order.
Your lordships can find it from page 17,
Yes.
and your lordships can find the reasonings from page 20.
Yes.
If I am permitted to read, not paragraph 6. The plaintiff has filed the above suit against the defendant seeking the relief of declaration that the plaintiff is the owner, is the absolute owner in exclusive possession and enjoyment of the suit scheduled property, and for the consequential relief of permanent injunction. It is submitted by the plaintiff that he is the absolute owner in possession of the suit scheduled property. Originally, Ratnama Samuel was the absolute owner of land bearing survey number 56/3 and
Till
23.
page number 6 about all that you have already stated
Please,
about the sale deeds and all.
please, my
You
lord.
can come to page 6.
Not even that, my lord, the page 6 is also what I have stated. Page 7, your lordships could see, my lord, what is the defense that has been set up at paragraph number 8.
Yes, yes.
On the other hand, defendant number 2 has filed written statement and objection to above IAS. Defendant number 2 has contended that one Albert James Giddens and late Margaret Elizabeth Giddens have only one son. They were father of defendant number 2, namely late James Eaton Giddens and his wife Philomena Margaret Giddens, and their 3 children. Originally, the father of defendant number 2 has purchased immovable property bearing survey number 56/3 and 23/7, Kata number 80, situated at Borewell Road, Kerpuram, Bangalore East Taluk, measuring east to west 93 feet, western side 35 feet, northern.
Say that survey number 23/7, Kata number 80. What is the suit schedule property?
Survey number is same, my lord.
Not survey number 56/3 and
56 bar?
and survey number 23/7. Out of that particular extent, your lordships can find the plaint that is produced along with the appeal papers.
Page number?
The
Come to 66.
My lord. In page 66 is the schedule.
66, if your lordships were to see, my lord. All that piece and parcel of portion, piece and parcel of property bearing 134/74/6, portion of old survey number 56/3 and 23/7, situated at Whitefield Village, Kerpuram, Bangalore East Taluk, measuring east to west 62 plus 62.6/2, north to south 119 plus 111/2, in all measuring 7,130 square feet, together with construction and developments found thereon, and the same is bounded on east, west, north,
Now
and
the
south.
dispute is with regard to the entire property or a part of it?
Entire property.
And what are the documents placed by you and what are the documents placed by them with regard to the possession?
My lord, your lordships could see, my lord, along with the memo,
Hmm.
a set of documents, my lord, which are already produced before the trial court,
Hmm.
are made available to this honorable court. My lord, that list, my lord, is filed on 30th of July 2000.
Hmm.
Your lordships could find, my lord. The list, these are all documents, my lord, which were
On the
filed.
sale deeds, after you purchased the property in the year 2004, thereafter.
Thereafter, your lordships could see the, my lord, from item number 19,
Page numbers?
page number, my lord, I'm looking at the index, my lord. Your lordships could get the list of documents that I have
Ah.
filed.
Yes.
Page number 3, your lordships could see, my lord.
Hmm.
This is the encumbrance certificate. Then the tax paid receipts. Then there is another tax paid receipt, then the Kata endorsement, the tax demand register extract, and the other tax demand register extract, the tax demand register extract. Then, my lord, another tax paid receipt, another tax paid receipts. These are the photographs that. Up to date, my lord, I've been paying taxes and Kata stands in my name in respect of the suit scheduled property.
What did they file?
My lord, they filed the registered documents on which they rely on,
Nothing else.
nothing else. Subject to correction from my learned friend.
Apart from the registered sale deed, nothing else is filed?
File the documents,
What are the documents you have filed?
record of rights was filed. Index of land is filed,
Index of?
index of land
Hmm.
to show that the return statement scheduled property was purchased by me.
No, anything with regard to the revenue, payment of taxes and other thing?
Yes, record of rights and the index of land shows that the assessment tax was paid by my father and it's still standing in my name, my father's name. And moreover, the scheduled property is not at all in existence, which is part and parcel of return statement scheduled property. My lord. They have not produced any,
According to you, when did you purchase?
I purchased the property in 1992.
You purchased from whom?
I purchased it from one.
Any of your
Is-
vendors or also, is there any common
There
connection?
is no common.
Way back in 1945, my lord, one common vendor is there. That
1950.
Ratnamma Shamyu.
Uh,
He sold the property in both the survey numbers by dividing two plots, and one plot is allotted to my vendors. And I derived the title from my vendors as my documents indicates the same. Lord. Actually, the property as claimed by the plaintiff is not at all in existence, because according to them, according to the plaintiff, their vendors have purchased the property measuring 1 acre 19 guntas in both the survey numbers. When it comes to the vendor of this plaintiff, it's all of a sudden bifurcated into 7,000 square feet only. They have not stated how it has been bifurcated and what happened to the remaining land. There the conflict arises.
No, according to you.
According to me,
1 minute. No, his vendor has purchased on 19 to 2004. So let us see this document of 19 to 2004. Where is it? That is at page number 27.
Yes,
Please
ma'am.
come to that.
The schedule your lordships can find.
27.
27
My lord,
of my
34,
documents.
34. My documents,
Okay.
34, my lord, is the schedule to the sale deed.
No, not your your vendor's document I'm looking at.
This is my vendor's document. It starts from
Document
27.
number 4.
Please, my lord, document number 4 is my vendor's sale deed. This commences at page 27 and your lordships can find the schedule at page 34.
34.
The very same extent, the very same measurement, the very same description that is there in
Property
the,
bearing 136/7/74/5. In all measuring 7130 square feet.
same.
Now, bounded west side so and so. Why these two are adjacent survey numbers, 56/3 and 23/7. How can it be a land in both survey numbers?
my lord, they are situated adjacent to each other. At
Survey
an-
numbers.
Both survey numbers are situated adjacent to each other. My vendor's vendor had earlier purchased the larger extent of property, carved out sites, one row of sites, and sold. There were as many as 7 sites which are carved out by my vendor's vendor.
Now
And-
let us see the sale deed prior to this. That is 22 to 26.
it's at page 22, Mina. It's a GPA.
My lord, page 17. Is
This
the,
also speaks about the square feet, 7,130.
please,
That's the GPA executed by one A Bose in favor of Ravi Purvanka.
who
That,
formed the
they
layout?
said, they said A Bose was purchased larger extent in that both survey numbers. That is 1 acre 19 guntas, which your Millard can get in page 17. Typed copy of this sale deed obtained by A Bose.
1 minute.
Registered sale deed dated 17/12/1965.
17/4,
17/12/1965.
1965.
By virtue of this sale deed, this said A Bose purchased the larger extent of 1 acre
How much?
19 guntas in the Bose survey numbers.
Not your lordships can find from page 20,
Yes?
20, 20, my lord. That would be
Schedule-
typed copy of the sale deed.
Schedule is mentioned there. Last 5 lines, my lord, is the schedule. All that piece and parcel of
Where is it? 20?
Page
20, page 20 of the type. Last 5 lines. Above the 5 lines, all that piece and parcel of land with the mango, tope and other trees thereon, about 1 acre and 19 guntas in extent. That is important.
I'm not able to see that.
Lord, last 5 lines from the bottom of the page.
Last 5.
The vendors have the date, so and so, mango, tope and other trees.
Please, my lord.
And
About
other
1
trees
acre
thereon,
and
about
19
1 acre and 19 guntas in extent with the dwelling house, outhouses and compound walls thereon, situated in Whitefield village, formerly called as Agdur village, Krishnaspuram, Obli, Bangalore Taluk, Bangalore district, bearing survey numbers 56/3 and 23/7. And bounded on east by Mr. Murphy's land, measuring on that side 150 feet. That
This
is
document is 1965 document.
65 document is
When it comes
1
to.
acre 9, when it
No,
comes to the
No, when it comes to 1992 document, it becomes 7,000 square feet.
7,130 square feet, because in between there is a registered general power of attorney, and the general power of attorney holder, my lord, that is a document number 3. This general power of attorney holder carves out sites, 7 sites out of the total extent that he had purchased in
there
1965.
is no basis.
One such site has been sold in my favor. That is exactly the recitals of the sale deed. And the general power, registered general power of attorney is also produced before the court at document number 3, my lord, that your lordships can find at page 22. It is a registered document. The very same person, my lord, A. Bose, who purchases the property,
Without any plan approved by any authority.
and that is,
This GPA might have
according
been,
to him,
this GPA might
according
have
to
been
him, my
given
lord,
both.
it continues
But
to be an
on what
agricultural.
basis he has bifurcated the total extent?
Yes.
Is the right
According to him, he says it continues to be an agricultural land measuring 34 guntas is his case. The property came, my lord, within the jurisdiction of, my lord, municipal limits. Not even prior to my purchase. My vendors, my lord, had kata in the, my lord, panchayat, in the municipal records. Subsequently, my name has been inserted in the name of my vendor. He does not have any kata. He does not pay taxes to the municipal authorities. He only relies on an old document where it used to be a survey number and say at that particular point of time, my name was,
Says that he has been paying taxes.
there is no, not like the documents that he has produced before the court along with a separate memo discloses that there is no tax paid receipt that is paid to the municipal authorities. Property is coming within the municipal limits for the last 20 years.
Is it so?
Revenue records are standing in.
No, not revenue records is a old thing. No, it's an urban property.
No, it is not assessed for tax by the municipal authorities.
Whereas in his
Still,
case, it
it's
is.
still in
assessed.
agriculture.
In his case, it is assessed.
They have created the documents in respect of non-existing property, my lord. That is the dispute. In guise of in guise
as
of
of
that
now-
documents, they're claiming
As of
portion in
now-
my property.
As of now, we can look into the documents which are existing, whether it is forged or otherwise, the court would decide. Now, both of you are raising the same with regard to the title, dispute with regard to title. So then when it comes to the interim application of injunction, we have to see any one of you had made any prima facie case. That's if you look at the documents, that is the plaintiff had made out a case with regard to possession.
That I am in possession of the written statement
what is
property.
the-
The
what
same
are the
property they are claiming, the same property
How-
there.
How do we say that now? Now, you also agree that it's
If
an
at all
urban-
they are in possession, my lord, they ought to file a suit for only injunction if I disturb them. Why they went for declaration? That itself shows that they are not at all in possession of the property.
That can't be the inference
My lord.
when you're questioning his title, he will file the declaration because mere suit for injunction is not maintainable. When the dispute arose, you must have said that I'm the owner of the property, so he must have filed a suit for declaration.
Both the parties landed
They're
up in the
saying
police
that-
station with a fight. Both the parties
That they have a
landed up in
valid
the police
title. What is the
station.
necessity to go for declaration?
And
If they are saying they are in possession,
For that, he will file a suit for injunction. He will come up with this kind of a written statement saying that I am the owner of the property and you deny his title. Then what he has to do? You already denied it in the course of this thing. That's why he has filed a declaration.
my lord.
No,
First
it
of
is
all,
a
my lord,
urban
the scheduled property has to be identified with that description, my lord. Because it's non-existing property. heavy burden lies on the plaintiff
No, for a
to
non-existing
prove the
property-
identity of the property.
Non-existing property, the municipality will, they will collect the taxes. For an existing property, according to you, what you are having, when it is in the municipal limits, they will treat it as an agriculture land.
Actually, I applied for the municipal records, my lord,
You have purchased a property in the year
92.
1992.
Then it was an agriculture land.
No, right from that date till now, when it has come into the municipal limits,
My lord, it came in the municipal limits, my lord, during the year 2006.
so suit is filed in?
2022.
But how can you say that from 2006 to 2022, though you're in possession of the property, they are not collecting any tax and you're doing agriculture in that?
Now, because of urbanization, it's
You
not
can't do
possible to do
anything.
that.
So then it has to be, the tax, everything has to be paid because it's an urban property. Municipality will collect the tax. Please come. Where is the order page number?
My lord, the lordships can find from page 17 onwards. After extracting them, not the case of the parties, the only observation that has been made by the trial court is at paragraph 14.
The present writ petition is filed.
And it's an appeal.
The whole difficulty is that everybody dealing with the same matters. The present appeal is filed. Agreed with the orders passed in IN numbers 1 and 2.
Lord, I have to make one fair submission to the court. One of the other respondent, my lord, who had put up a another
He
case
has
of
also set
title,
up
his
his
notice
own
is
title.
not yet issued.
Yes.
His notice is not yet
Not
issued in the
issued.
present appeal.
Not
Not
sir.
yet issued. Not yet
Then why
issued.
are we here? Not even issued.
Not issued, but on the last date of hearing, brought to the notice of the court, your lordship wanted to see, my lord, whether a case is made out, then my lord will consider. Therefore, at this particular point of time, my application for interim relief may kindly be considered.
The present appeal is filed. Agreed with the orders passed in IN number 1 and 2 in OS number 426 of 2022, dated 27 January 2024. Whereby the court below had dismissed an application filed with the petitioner, filed with the appellant plaintiff seeking injunction. Seeking injunction and also seeking not to alienate the.
Not to alienate and not to interfere, two separate applications. were
He has filed one application seeking not to alienate the property, and other application is filed seeking not to interfere with his peaceful possession and enjoyment of the property. The court, it is a case of the plaintiff that he has purchased the property by way of a registered sale deed and dated 11/3/2004. Whereas, and according to the plaintiff, his vendor has purchased it 19/2/2004. And his vendor has purchased on 7/5/1992. His vendor on 17/12/1965. And the first purchase is on 3/6/1950. It is submitted that the right from 1950, till now, even as per the EC also, except the sale that is in favor of the plaintiff in the year and on 11/3/2004. Four, there is no encumbrance on this property. The plaintiff is a non-resident Indian, and when he has fenced the property, when she has fenced the property, came to know that the fence was broken. Then when they wanted to construct a compound wall, that the defendants started interfering with his property. The defendant had interfered with the same, as it made him to file the suit. The defendant number 2 sets up a title to the property, denying the title of the plaintiff, citing that he has purchased the property by way of a registered sale deed. Your Defendant number two.
Two.
Defendant number three also states that he has purchased the property.
He claims under a memorandum of understanding.
He claims the property under a memorandum of understanding. And according to them, according to the defendant number two, he had purchased the property in the year 1992. And his name is situated in the revenue records. The revenue records. The trial court had dismissed the application, both the applications. And while dismissing the applications, the court has observed that the parties are setting up, both the plaintiffs and the defendants are setting up title to the property basing on sale deeds. And the case has to be proved during trial. And the plaintiff has failed to make out a prima facie case, and the balance of convenience do not lie in favor of the plaintiff. Learned counsel appearing for the plaintiff submits that next part. Learned counsel appearing for the plaintiff submits that he has filed the municipal tax receipts up to date to show that he has been in possession of the property. According to him, the defendants have nothing to do with the property, and the court had failed to consider any of the submissions and the documents that are filed on behalf of the plaintiff, unless and until an interim injunction is granted, it would cause irreparable loss. Learned counsel appearing for the defendant number two submits that there is no property existing that is a sue scheduled property. According to the defendant number two, he is in possession of the property. He is relying on the sale deed of 1992. And as far as the possession is concerned, admittedly it is an urban property, but the defendant had not filed any document to show that he is in possession of the property. Considering all these aspects, in the considered opinion of this court, prima facie, the petitioner could prove that he is in possession of the property and he has fenced the property. And if an injunction is not restrained, the balance of convenience is also in his favor and there would be irreparable loss. Hence, there shall be an injunction restraining the defendant from interfering with the possession of the plaintiff till the next date of hearing.
They asked only for not to alienate.
No, both he has asked, 1 and 2.
Both I have asked before the trial court.
1 and 2. Look at it.
Here the interim application
It's only not to alienate.
not to
Yeah,
alienate.
here, my lord, in the present appeal, it is not to alienate.
Is not to
That
alienate.
can't be granted. That can't be granted.
Your lordship can mold the relief and
What you want, the question of molding also does not arise. In that case, no. The petitioner is seeking a relief of not to alienate. If that is the case, IA has to be dismissed. This court is not inclined to grant it. Till that time, that injunction, the court below had dismissed and the contentions and the defendant contention there. Before this court, the IA that is filed by the plaintiff is not to alienate. The relief of not to alienate cannot be granted as according to the plaintiff, that is, he has purchased a property by way of a registered sale deed and the defendants have their own sale deeds which are of the year and they do not have any common vendor. And in such event, question of granting the interim relief of not to alienate will not arise. Accordingly, IA number so-and-so in so-and-so is dismissed. The issue notice to who?
Respondent number 3.
One is served, you are representing.
One is died.
one is dead.
One is
Dead,
Died.
no more.
issue notice to third respondent. Post after service of notice. Yes.
But liberty may be granted to file a fresh application so far as interference is concerned.
Anyway, by the next time it comes, we will hear away. Anyway, court will allow your petition itself. Why do you worry about? Yes.
23.
Permitted to serve on the advocate who appears before the trial.
Oh, hand summons. The petition is permitted to take hand summons to the counsel appearing for the third defendant. That is the third respondent herein before the trial court. And file a memo to
Second
that effect.
respondent before this court, third defendant.
Second respondent and the third defendant before the trial court and shall file a memo to that effect. Yes.
Number 23, MJ Arrears.
Yes.
Respondents appeal
Yes.
against the order of injunction granted by the trial court
Yes.
in an application under section 9 of the Arbitration and Conciliation Act. The impugned order, your lordship will find it at page 14, annexure A.
Yes.
Now, my first submission, so far as the question of law is concerned, your lordship may kindly consider this application was filed on 21/11/2022. Your lordship will find the date at page 29. It was filed on 21/11/2022. And this order was passed on 15th April 2024. In between, there is a gap of more than 2 years. Now, I invite your lordship's kind attention to Rule 9, Sub-Rule 4 of the High Court of Karnataka Arbitration Proceedings Rules 2001. These rules I have extracted in the appeal memo itself. Your lordship will find it at page 8,
Page?
para 2. I have extracted it.
Yes.
Grounds para 2. The trial court has failed to consider
Compare it for me.
ink page
Yes.
8,
Yes, yes.
para 2. The trial court has failed to consider Rule 9(4) of the High Court of Karnataka Arbitration Proceeding before the Court's Rules 2001, which reads as follows. In the case of an application for interim measure made before initiating arbitral proceedings, if the arbitral proceedings are not initiated within 3 months from the date of the presentation of the application under section 9, any interim order granted shall stand vacated without any specific order being passed by the court to that effect. Therefore, my submission is,
So, please read it again. In the case of an application for interim measure
Yes.
made before initiating
yes,
arbitrary
when
proceedings.
the court is not competent to pass an interim order by virtue of this rule, if at all any interim order is passed by the trial court on this application, that is along with this application at section 9, if they had filed one more application for interim relief, that injunction has to be vacated automatically for this reason, that they have not initiated arbitral proceedings within 3 months. That being the case, my humble submission is, when the law mandates that they can't maintain, they are not entitled to seek injunction, then question of granting injunction at the later stage doesn't arise. I can pass on the book also for the assistance.
Please pass it.
Rule 9, Sub-Rule 4.
Yes.
What the law mandates is, within 3 months from the date of the presentation of the application for interim relief under section, please. Therefore, my humble submission is when the court is not empowered to pass order, question of granting relief at the final stage doesn't arise.
What you're submitting that I'm not able to understand from the provision. In the case of an application for interim
Please,
measure made
please.
before initiating arbitral proceeding,
Please,
if the arbitral proceedings are not initiated within 3 months from the date of presentation of the application under section 9, any interim order granted.
shall stand vacated without any specific order being passed by the court to that effect. Now, when the court is not empowered to pass an interim order of injunction on an application under section 9, because your lordship may kindly consider, an application under section 9 will be filed before the trial court. Along with that application, my lord,
Or in this case, when was the notice served on you?
my lord, that was filed by the respondent, my lord. It is not my case.
No.
This
When the notice was served on you?
My lord, it was served immediately. I have not mentioned it, but it was served immediately. Then we had appeared and filed our objections. Then finally, the learned judge had passed the order allowing this application under section 9, and the impugned order came to be passed. The lordship will find it the operative portion at page 27, ink page 27.
Have you taken such a contention before the court?
My lord, so far as the question of law is concerned, we did not take up.
No, I'm asking.
My lord,
I'm asking you have you taken.
it was a matter by the it is a case from Mysore. So I'm not aware whether such
We'll pass
contention.
orders tomorrow. Tomorrow.
And
Was this
this
matter?
is one submission. So far as the other aspects are concerned, your lordship may kindly, this is one point, this question of law. The other aspects are concerned, your lordship will find. Kindly turn to Annexure B, that is the joint development agreement. Now their point is that there is joint development agreement entered into between these respondent and these appellants in respect of certain properties. And it is also their case that immediately some other persons had filed a suit pertaining to the very same property. The lordship will find the plaint copy at Annexure D, page 72.
No,
A suit was filed.
1 minute. Before you, let me just look at the order so the
Please.
things would be clear.
Not to alienate. May I read, my lord?
Yes.
Petition filed under section 9 of the Arbitration Conciliation Act is hereby allowed. The respondents by way of temporary injunction are restrained from alienating the scheduled property till resolution of the dispute as per arbitration clause in the joint development agreement, or entering into a new joint development agreement or modified joint development agreement between the parties, whichever is earlier. Now, your lordship may kindly appreciate, as per this order, the learned judge says that till it is resolved in an arbitral proceedings. They have not commenced any arbitral proceedings either to, despite the mandates of Rule 9. It is uncertain when they are going to initiate arbitral proceedings. Therefore, my humble submission, this kind of order cannot be passed. At least if the learned judge passes an order with the time-bound specifications, then things are different. A vague order cannot be passed. For any reason, if they doesn't want to initiate arbitral proceedings, then what will be the effect of this order, my lord? It will lead to uncertainties. Therefore, my humble submission is this
As per
order.
the arbitration clause and development agreement dated 6/11/2007.
Please, my lord. The joint development agreement I have produced at Annexure B, my
Arbitrator
lord.
was appointed.
My
What
lord,
is the finding at page number 6 of the order? Earlier it was appointed in view of the compromise proceedings before the.
please, my lord.
came to be
Now,
closed.
therefore, this arbitral clause, arbitration agreement has been superseded with the subsequent events. A suit was filed in respect of the very same property, wherein a compromise was entered into you. My lord,
Against you.
against me and others, wherein this respondent was also a party. Therefore, I had drawn your lordship's kind attention to the plaint at page 72. Kindly turn to page 72, my lord. One Venugopal and two others had filed the suit. Your lordship will find these appellants appellants are the defendants 2, 3, 4 and 5. And 6 is the respondent herein. 6 is also a party, my lord. And this suit ultimately ended in a compromise. Your lordship will find the compromise petition at annexure F, page 90. Page 90.
Yes.
There also your lordship will find the name of this respondent as defendant 6.
Yes.
Now, my lord, there are certain terms and your lordship will find at page 96. In view of this compromise, the defendant 1, 4, 5, 6 and 7 and 8. It is in page 96, my lord, para 18.
Yes, I'm looking at that.
Please, my lord. In view of this compromise, the defendants 1, 4, 5, 6 and 7. 6 is this present respondent, my lord. And 8 have agreed to close the arbitration proceedings because there was already an arbitral proceedings pending in respect of the joint development agreement dated 6/11/2000. That is the joint development agreement in
The
question.
court has granted the order of not to alienate. You
Please, ma'am.
also do not agree, you also not disputing the fact that there is a compromise decree and a MOU that is entered
No,
is
my
still
lord.
in existence.
Lord, in furtherance of this compromise, my lord, a compromise decree was passed and this respondent had filed execution petition. That order, your lordship will find it at annexure J, page 105.
No, that is altogether a different issue. Your agreement between A and B.
Please, my
and
lord.
the suit between A and C,
Now,
where B is entered.
Now my submission is that agreement has been superseded with this compromise because all the parties in the suit were not the parties in this joint development agreement. It has been virtually modified, rather superseded. When a new contract is entered in between the parties, and even otherwise, your lordship may kindly consider there was an earlier proceedings in respect of the very same joint development agreement, and an application under section 9 was filed. Your lordship will find that order at annexure E, page 78. Kindly turn to page 78.
No, instead of precipitating this issue, let them come, we will decide a short date. Because it's a very
Please, my
simple
lord,
issue.
let there be a stay on this order, my lord. Let them
And if
come.
you alienate,
My lord,
to alienate the property, now the whole purpose of it will be frustrated. That's why take a hand summons to the council appearing to the petition permitted to take. hand summons to
let
the
them
council.
notice go through the process of court, my lord, because
Notice.
sometimes these parties will be
Respondent. Notice
only
to the
one
district
party.
director to issue.
Emergent notice may be ordered.
Emergent notice to the respondent. Post after service of notice.
Post immediately after the service.
Post immediately after service of notice. Yes.
Great.
4. Anjula L. for petitioner. Anjuna 3.
Hearing for the respondent, my lord.
Your Lordship, this matter has been filed by the petitioner seeking a relief of, since being aggrieved by the lower court, an order of enhancement of rupees 15,000 was ordered, wherein earlier 10,000 rupees was paid to the respondent. Subsequently, the lower court, upon announcement of rupees 25,000 was sought by the respondent. For that, an additional amount of 5,000 was granted by the Honorable Lower Court, at which time being aggrieved by the
What is the
order.
initial amount granted?
Initial was 10,000 rupees, which was paid continuously, and it's been paid also.
When was it granted 10,000?
That was in the year 2008, based on the, it was in 2011, Your Lordship, after
Then
mediation.
enhancement was sought when?
From then, it's been continuously been given by the petitioner.
Enhancement, when was it?
Enhancement was ordered recently, that is in 2022.
By
Based
way of
on-
this order.
by way of
How
this
much
order.
is increased?
5,000, so it's
It
upon
becomes 15,000.
15,000, Your Lordship.
What is the income of the husband?
Right now, he's lost his job and he's
Not right
depending-
now, as on the day that order is passed.
That day, it was around 40 to 50,000, which He was earning, but right now, it's more than 2,000 since COVID, he's lost his job and he's depending
This
on
is
his,
qualification.
MCA, your own. MCA, Master of
MCA.
Computer Application. Sort engineer essential.
And from 2000, from when he is without a job?
Past 2022, during COVID, he lost his job, Your Lordship.
From 22 to 24, no job.
Yeah,
for him.
he's depending on his wife where he's now got married again. Through that wife, he's got another child. And so he's got his aged parents, all of them together. And with this pressure, here
Divorce, the permanent alimony is not
it's
granted.
paid, 12 lakhs was paid. All the entire, whatever valuables belongings were there were handed over directly to the respondent. And an amount of rupees 10,000 has been paid from the time it was being ordered in the mediation center till till even now. But then she files an application for another petition for enhancement, based on which this order was passed.
Let's see the order. Yeah, she has received 12 lakhs alimony.
Oh, yes, sir.
Yes.
To
Come to the
23rd
order.
November 2022 is the order, Your Lordship.
Please come to that.
Yes, Your Lordship.
When was the divorce?
Divorce is in 2011, Your Lordship.
2014, your lordship.
14. But the amount has been paid from then. She's been receiving the amount. She's also received this permanent alimony amount. And she sought this enhancement, which it's now, right now, he's not able to pay this amount. So, but here, it's another thing which has to be told, where the respondent, she's herself a practicing advocate, got her independent source of income. Apart from that, she's the only daughter for her parents, but both the parents are not there. At least the father, he's left behind lots of property. And now this particular child, who is the respondent herein,
She's not taking it for herself, for the child.
for the child, 10,000 was paid, Your Lordship. And then another application was filed.
But till
Yeah,
now,
previously it
till
was
now you're paying
before-
10,000.
Yes, Your Lordship.
Till now, you're paying 10,000.
Yes, Your Lordship. Yes, Your Lordship. It's already paid.
Arrears.
If your Lordship recollects, it was before this honorable court, before,
Remember.
after that, the memo of calculation was supposed to be filed, which was not filed. Thereafter, it was posted for after vacation, but then she moved an application for vacating the order, for which stating that she is likely to pass her SSLC, and thereafter she has to pursue her higher studies. Vaguely, it was mentioned as 3,50,000 rupees is her amount which she has to pay to the college. Thereafter, this honorable court had been pleased to direct her to produce the documents which is required to see that how much she is paid and where is she studying. If your Lordship may kindly see, there is only one certificate which has been issued, which is pertaining to one college at Ujjire, which doesn't say anything as to how much it's paid, but it says this is how much it is, and the child is here. And there was also an order by this honorable court to seeking that necessary after that application is, or after that document is produced, to make necessary arrangements to either go see what the child, whether she is there. So the petitioner has made all efforts to go there, see, find out, but absolutely there is no, at least to say whether the child is there or not, he was not entertained into the campus itself. So he's not, neither he's able to see the child. And one more thing is, like, at this age, when she's first PUC and she's staying in some other distant place, if the parent or the respondent number one had all the difficulty to take care of the child, she could have handed over the child at least to the father. He's ready to take care of the child, but now she's left alone in the thing. I do not know where. So far, the child has not been shown to the father from past 10 years, Your Lordship. That is from 2014 till now. Even when this honorable court had been pleased to send for mediation also, there also she refused to show the child. So this is how the respondent's attitude is. But only thing, saying that 3,50,000 rupees has to be paid. But last time, due to some other matter I was held up, and which time this honorable court, though I'd asked my client to get it passed over. Meanwhile, the order has been passed saying that the stay has been vacated and this much amount has to be paid by the petitioner and also to execute. So immediately the respondent has gone to the family court again. She sought for execution of this order. So this is the present instance where the petitioner is now standing, Your Lordship. He's paying 10,000 where he's got, at least with all the difficulties, he doesn't have anything. He has to, as a father, he's ready to take care of those library. But here, though she says that 10,000 is not sufficient, then she again seeks for educational expenses. Also, she says enhancement. It's totally that she wants only that child to be taken care, or what is her intention? It's absolutely not known before this. So this is where the petitioner
My
is now
lordship,
standing. Lordship.
My lordship, I have to bring one enlightenment of this honorable court. They opposite the counsel continuously, they're seeking the adjournment. And all this fact the court come to know, then they give the, okay, this stay order because of the minor child need the education expense and other things. So, and a lordship, the father filed the RPSC petition against the child in this case, your lordship. The child need the when they file the case, the child is studying board exam, 10th board exam. Now she's take the admission first PU in Udupi.
Is it correct that the father had never seen the child from the last 10 years and you're not the
He cannot,
family is not
she
permitted?
cannot file any GNWC case and nothing. And also in judgment, the family court clearly told that in 226 of 2011. No. In 10, I lost, I give the certified copy. He admit that in spite of the order dated 17/11/2015, he has not visited his daughter. The respondent has offered to take care of his daughter, but the material before the court disclosed that he has totally neglected the second petitioner. Second petitioner, the minor child in this case, your lordship. And again, this one, in this 226 of 11 judgment, what the 10,000 has passed the trial court in this case. And again, we filed the enhancement petition and seeking the enhancement is 30,000. The trial court has granted only 5,000 to the minor child. And in this case also, in cross-examination, we asked the petitioner, one minute, lordship. And you have visit your child and you file any GNWC case. He told that I will not file any GNWC case and he cannot show any record. His only intention is harass the child. He thinks that he married another wife. They are not ready to give enhancement of maintenance to the minor child of his own daughter. So I request this honorable court, the law 22nd 7, yes, this honorable court has vacated the stay order because of the child need the education expenses. So my humble request this honorable court kindly dismiss this appeal and impose the expense cost, my lordship. This is my humble submission. And also I filed the memo of calculation in July 1st week. And also I filed the education expenses regarding the minor child. I filed him, my lordship. Yes, this is education expenses. The child requires 2,45,000. The total, the child, the trial court has granted the 15,000 is per year, per annum is 1,80,000. Another amount is also required. This is the last session they asked told that please give the details of the education. Yes, I will file. I will file education expenses and memo calculation.
Have you filed a writ petition or they filed?
No, this one is RPSC. They ask in the same case, please file the education expense details.
No, that is true.
Yes.
No, this writ petition is filed by them. You have not sought for any enhancement.
Yes, I will not file any enhancement
So
in this court.
let's hear them. Yes.
Now coming to the point that the
What is
petitioner
the material-
petitioner has not seen the child.
What
Your
is the
Lordship.
material placed before the court saying that you have no source of income?
That I'll produce it, Your
It is
Lordship.
not
That is,
that,
all
is
the
produced.
records have been produced before the lower court
By the
during
time
his.
you were working,
No, by that time, this was only in 2022. So COVID started during 2020. So by that time, he had lost his job. So all those
where is
documents.
the finding of the court? Please come to the order.
Yes, Your Lordship.
Then how will you pay 10,000?
No, 10,000 he's paying because he's now got married. His second wife is
So his
help.
second wife is providing
She's
10,000
working, she's
to-
working in a software company. She's now assisting him in all this household affairs and also rental income, which is coming as a low rental income to his parents. He's managing it, but with this matter, he's
So
not. able to-
5,000 is that something? which
Additional
he can't
burden
manage?
because he's got now, through the second wife, he's got, she's also divorcee where she's got one
I
more
can
child.
understand.
So
you
he's
can't
got
pay.
family liabilities, Lordship.
I can understand you can't pay, but 10,000, 15,000.
10,000 is, 10,000 he's never disagreed at all. He's been paying even now, very
Yes, please come to
honestly,
the
he's been paying that amount, Your Lordship.
Come to the order.
Yes, Your Lordship. If your lordship may kindly see the, it's very clearly mentioned in the, at para 20, during the cross-examination of PW1. She has admitted that she's a practicing lawyer from January 2021, though she completed LLB in the year 2003 and enrolled in the same year itself. She does not know whether parents of the respondent are still alive. She has admitted that 12 lakhs was given to her as permanent alimony in MC so-and-so number in the year 2014. The petitioner has not denied the suggestion that the respondent has married again and has 2 children. Further cross-examination of PW1 reveals that her native place is Bhadravati and she is the only child to her parents. Her father is a retired person. She has not denied the suggestion that her father owns agricultural lands, but admits that her father owns a house. She has denied rest of the suggestions of the respondent that her father has enough source of income and her mother has gold worth 20 lakh rupees. This is all towards the respondent number 1, your lordship. She is presently residing at Nandini layout in the house, which is owned by her, but she has voluntarily agreed that she has taken it on lease. Rest of cross-examination of PW is not worth to be discussed because it's beyond pleadings to the both the sides. Then further, the learned court also finds that she has denied the suggestion that she monthly earns from her profession 50,000 to 1 lakh rupees. Another suggestion that she has filed this petition only to harass the respondent and to squeeze money from him and to send him behind the bars. As per the respondent earlier, he was working in Accenture. This is the place he was working, your lordship. And now he's removed from that company due to COVID-19 pandemic. He has no suitable job and he is depending upon his brothers and in-laws, but she has denied the same. So this is the, in the cross-examination also, and particular documents have been produced before the lower court, your lordship. So again, in his evidence also, he produces all these documents, your lordship. It is also mentioned as, if your lordship may kindly see para 24, finally the respondent brought on record exhibit R12 letter dated 23/11/2020, which reveals that the Accenture company, being the employer of the respondent, on the basis of his resignation, relieved him from his duties. So as of now, from then till now, he's unable to find the job. And further, there's also further, during his cross-examination, respondent has said that he's a science graduate. He's working as a delivery boy on daily wages. Earlier was working in Accenture. So this is where he was working in a very good company, but then he lost his job. As of now, he's still yet to find, but with this mental condition, he's unable to find any job. So this is his present thing where 10,000 is managing to pay. But again, this additional burden of 5,000 rupees, and each and every time she'll make a point to see that she gets an FLW or NBW against him. She takes him to the station at Nelmangla, makes him sit there. This is a habitual routine sort of thing. And
Let him pay
though, even a month, if
Call
it's
that.
delayed, even a month, she just sees that the police goes in a house. Now again, when the court has been pleased, without even the order copy, she immediately goes and files an application for advancement. It's sent through registered post.
Because, Your Honor, what she told always is far from the truth. Because they will not follow the NBW, immediately the police will ask the action and take the NBW in court. So the court told that, please clear all the arrears. What is the wrong in that? And also in 226 of 11, he clearly admit that, I will produce this order sheet. The petitioner has produced 2 sale deed. I will show this 226 order, Your Honor, please. That one is 7/35/2018. The petitioner has produced 2 sale deed as per Exhibit P 21 to 23. Exhibit P 21 disclosed that the respondent has purchased the site at Anekal Taluk, Madiwala village, Bangalore. Exhibit P 23 disclosed that the petitioner, the respondent has purchased this site at Nelmangla Taluk. Exhibit P 28 disclosed that.
When did he purchase?
He purchased in 2011, my lordship. This was the order sheet of 226.
Right now, what is mentioning is the 2001.
Order
which
sheet. Now
first
also
went-
the site is in his
That
name.
is the previous one where 10,000 was ordered, and subsequently she files the enhancement. So the finding has already
I
been,
thought that he has a lot of
based
source.
on that only rupees 10,000
He
has
was
been ordered, your
harassment of
lordship.
minor child. He simply told
That
that
case,
he married another woman and his own child.
That is the
So
only, that is the
difficulty
only
I
problem.
faced.
That is the
I
only.
no need to give the 5,000 what the trial court has ordered. I will also produce the memo calculation in this court, and also I produce the education expenses. He also admit that he has an MCA graduate. Now the arrears recovery stage come, they told that I have no job.
Yes.
This is the face the minor child has day to day she face.
The present petition, RPFC is.
RPFC, man.
Again, agreed with the orders passed in criminal miscellaneous number 7/30 of 2018, dated 23rd November 2022. The present petition is filed by the wife under section 127 of the CRPC, filed by the minor through petitioner through her mother, against the respondent seeking enhancement of monthly maintenance from 10,000 to 25,000. The facts of the case are that the marriage has formalized on 28/8/2005 with Durga, and out of the wedlock, they were blessed with a daughter. In view of the differences between the parties have obtained the earlier criminal miscellaneous number 226 of 2011 is filed, seeking monthly maintenance of 30,000. And initially a maintenance of rupees 8,000 was granted to the mother. During the pendency of the criminal miscellaneous number 226 of 2011, the husband had filed MC number 2758 of 2014, seeking divorce.
He filed the divorce petition, Lordship. He filed the divorce petition MC 2758.
That's what I said.
That is what. Yes, sorry for the interruption.
That's what I said. It was referred to BMC and the settlement, and it was settled. As per the settlement, the husband had paid permanent alimony of 12 lakhs to mother, to his wife. And it was agreed that the mother can prosecute criminal miscellaneous number 226 of 2011 regarding the maintenance of the minor child. And the marriage was dissolved as per the order dated 9/3/2015. And the husband had filed has paid the permanent alimony. Earlier, by order dated 11/7/2017, the court had granted 10,000 maintenance to the minor child in criminal miscellaneous number 226 of 2011. It is stated that the mother is unemployed as she has no source of income. She is facing difficulties to raise the child and also meet the necessary expenses, as 10,000 is not sufficient, and is working in Accenture and drawing salary of 1,000. Sought for maintenance of an amount of rupees, enhancement of maintenance from rupees 10,000 to 25,000. It is his case that after the divorce, he had married another woman, and out of the said marriage, he had 2 children. He lost his job during COVID, and he has no sufficient source of income. This petition is filed only to harass him. It is his case that she also gets income from the rent, as she owns number of houses. As she is an advocate, she is harassing the petitioner, by harassing the husband. The trial court, considering the maintenance that was granted in the year 2017, rise in the requirements of the child, the educational expenses, and considering the evidence placed by both the parties, particularly, court had considered the documents filed on behalf of the husband, and the school fees he is paying to his daughter out of the second marriage. And also exhibit R5, which shows that he has to take care of his daughter from the second marriage. And other medical records. And also the fact that he's irregular in paying monthly maintenance to the daughter. Also the fact that it is his case that he has filed GNWC case to sue his daughter to have custody or to have the visitation rights of the daughter, but no document is placed by him before the court. And also considering his case that he was drawing rupees 72,000 while working in exchanger. The statement of assets and liabilities filed by the husband dated 1/10/2021 reveals that he is working as team leader, but he has not mentioned regarding his monthly salary. It shows that he's been paying 10,000 per month towards the maintenance of the daughter. Court has also considered the fact that he is living in a house which belongs to his parents. Considering all these aspects, court has felt that the maintenance can be enhanced from 10,000 to 15,000. From the date of the petition till the daughter gets married, and it would meet sense of justice. Agree thereby the husband is before this court. This matter came up before the court on several occasions. Interim order was granted on 26/10/2023. The court has directed to deposit an amount of rupees 1,35,000 for which the default order is passed. Several times this matter came up before this court. And it is the case of the point that the maintenance is not paid as ordered by the court.
The amount is deposited, Your Lordship. Even 1,35,000
That
is
amount is
also been
10 lakh
deposited,
arrears, Your Lordship.
also been paid.
The amount is
1,35,000.
arrears of 10,000.
I understand the facts, both of you don't have to tell. Please. What did you write? There are arrears of maintenance, except that 1,35,000 that is ordered by the court. And by the court, no, matter came up today and counsel appearing for the petitioner submits that, petitioner husband submits that he's not he's jobless, is not having any employment. In fact, is depending upon his second wife. She submits that he's an MCA graduate, but in the COVID, he lost his job. Now the court, without any basis, had enhanced the maintenance from 10,000 to 15,000. It is a case that he is able to pay 10,000, but 15,000 would be very difficult for him. Then it is submitted that the respondent, the mother being an advocate is coming up with one application of the other and harassing the petitioner. He stated that he had never seen the daughter from the last 10 years. And even before the mediation also, the mother has not brought the child. It is submitted that the paying maintenance of an amount of 15,000 is beyond the capacity of the husband. And the petition has to be allowed by reducing the amount to 10,000. Next one. Then counsel appearing for the respondent submits that when the permanent alimony was granted, court had permitted the mother to pursue the matter with for maintenance as far as the minor is concerned. It is submitted that there are arrears and he was never regular in paying the maintenance amount. And the submission of the land counsel, the petitioner about the respondent not allowing the father to see the child. It is submitted that he had never made any efforts to see the daughter.
Kindly one intervention, Your Lordship. Here, she's changed the house, even including the
All
address.
those arguments not necessary. I'm recording
least-
our contentions.
But
You
it should
heard
be-
it.
Yes, Your
My
Lord.
lord, on
For
submission,
that
please.
particular reason, I need to say that she's not at the house where she's mentioned here.
My lord,
She's not given her address anywhere. He doesn't know where to go approach in this
same
matter.
It is submitted
Absolutely
by the-
false.
my lord, one
It's absolutely
submission,
false.
please. She is not working advocacy regularly. She is not, she have no any one case. Yeah. Any one case is not, he is a housewife and she is take care of the child and his mother. She is not practicing advocacy.
Why is she wearing a band?
Sorry.
Yes,
Because she does not know the English properly, my lord.
I understood the no for arguments are required. Yes. To see the daughter and even in the cross-examination, in the maintenance, in the divorce petition also. He has stated that he has not filed any GNWC and there is no intention to file the GNWC. It is submitted that the mother is not having sufficient income to maintain the child and it's the responsibility of the father to take care of the child, which he failed to discharge. It is further submitted that it is further submitted that the girl has completed her SSLC and she required the requirement for her education has also now increased. And when the wife had asked for 25,000, court had only granted 5,000. And that also, being a father of the child, he has failed to take that responsibility. In response to that, then counsel appearing for the petitioner submits that the whereabouts of the mother or the child are not known, as there is no a specific address for them. As such, he could never visit the child. Next one, having heard the counsels on either side, there is a material on record. The unrepeated facts in this case are both the parties or the mother and father have obtained a mutual consent divorce, and in the said proceedings, a permanent alimony of 12 lakhs is paid to the mother. Thereafter, the father had got married and in the out of the said marriage is blessed with a daughter. It is his case that he has to take care of the responsibilities of the daughter, the aged parents, and he has lost his job. Earlier he used to work, he is a MCA graduate and he lost the job, and from the last 2 years, he's not working. But at the same time, he submits that he can pay 10,000, but he cannot pay 15,000 to the daughter. It is also an undisputed fact that the father had never filed any petition under the petition, he has never filed a GNWC petition, nor he has sought for visitation, right? Visitation of the, sought for any order of visitation to the daughter. He has filed some of the exhibits before the court stating that he had to spend so many, so and so amounts towards education of his the daughter out of the second marriage. Being a father, he has a responsibility to take care of the daughter. Admittedly, he got remarried and he has not made any efforts to seek for the custody or he has done anything for the maintenance of the child, except my child, and even the order that is passed by the court is also not complied with, and he is being very irregular in paying the maintenance. The mother, it is as per the evidence on record, she is getting a meager amount of 5,000 per month, and for that it is not possible for her to take care of the daughter. When the husband is he says that he's not earning anything at one breath, and he says that he can pay, is able to pay 10,000 in the considered opinion of this court for the needs of the daughter. Even that 15,000 what court has granted itself is in a way is not sufficient. But still, as no appeal is preferred by the mother, this court finds no reasons to interfere with the order passed with the court below. Accordingly, the petition filed by the husband is dismissed.
Bill number 25.
At least let there be a direction to her to furnish the address where where she's presently staying, because
The same address,
in
my
to
lordship.
file a
They always
GNWC, he
say
has made his
trouble
efforts, your lordship.
and give the
So far-
confusion to the court also. And now the arrears of balance
This is how
amount is
she's been managing.
3,95,500 rupees is. Last time 22/7, this honorable court has vacated and also direct to the respondent is the liberty to execute the order and collect the arrears amount of 3,80,500. This amount is July. July is also, this August is
Only
also
amount
increased
which is-
15, another 15,000.
It is only
This
the amount which
is
is
added
mattering.
3,95,500.
As a mother, it's a
another
duty to show
15,000
that the
is added,
father
my
also
lordship.
has to see the child, but so far she's not made that effort.
For
So
that, the
kindly-
provision and the
Yes,
remedy
your,
is somewhere.
please, your
not
lordship,
before
but
this court.
let she be directed to furnish a residential address so that he could take the necessary steps for that, your lordship.
Bill number 25.
Much obliged.
Salim Ali Khan, yes. Petitioner.
Yes. No representation for the petitioner holds this matter on 2nd of September. Just next, there's just look at it, stays there. If stays there for dismissal. No, if there is stay, post it for dismissal.
Bill number 26.
No, you called this 26.
25. Now, the 26. Second BS.
It's appearing for the petitioner, my lord. But the RPFC, my lords, has been filed by the husband, my lords, against the order of the order in criminal miscellaneous, my lords. Lords, the short question, my lords, is regarding the amount that has been granted to the daughter, my lords, and from the date of the order that has been done, my lords. He is ready, my lords, to give the amount. But the problem is, my lords, he is having now the arrears of
How much is the maintenance plan?
lords, the maintenance, my lords, 10,000 per month from November 2021 to the daughter, my lords, and 4,000 per month to the wife from July 2014 to December 2018. That is 4 years and 5 months, my lords, and
Is she married?
no, my lords, she got a work, my lords, in the same school, and that is why she has not been granted maintenance, my lords.
Husband filed for divorce, came to be rejected. Wife filed for RCR, came to be allowed. Maintenance of petition has been allowed. At present, 8 lakhs is arrears.
Lords, the
8 lakhs
MFA,
arrears.
MFA has been filed, my lords, and it has been admitted, my lords. Lords, the problem, my lords, for the husband is the arrears, my lords, is now up to 8 lakh rupees, my lords. My lords, he is only seeking for a modification, my lords, of the 10,000 which has been granted from January 2021, my lords, till the date of marriage, my lords. If it is modified till the date, from the date of this receipt of this order, my lords, he will be satisfied, my lords, because now he has having salary of 50,000 only, my lords. He is having one mother, my lords, who is of age 70, my lords. So because of those issues, my lords, he is
Why did you keep quiet all through without paying the money?
my lords, I have paid the money, my lords, in the MC case, my lords, to the daughter. 5,000, 3,000 was ordered, my lords, in the MC case, my lords, where I have been continuously paid, my lords. Where I have continuously paid rupees 3,000 from the month of December 2015 to December 2020, which also reflects in the order, my lords. Now the other arrears, my lords, come up to 8 lakh rupees, my lords. That is because of the amount that has been given from the date of petition, my lords, from the date of.
It has to be, we have to consider the needs as on from that day.
My lords, even my lords, from that,
Can have some installment, it can't be from the date of order.
my lords,
Now he has only paid 1 lakh for it.
Who will pay and take care of them from the date of petition?
my lords, from the date of petition, my lords, MC case has been filed, which has been, we have been giving, my lords.
Where, how much you are giving?
My lords, 3,000 was ordered, my lords.
With 3,000, how both the mother and
No, my lords.
daughter will live?
The order was only for the daughter, my lords, because the wife has got the job, my lords. That is why,
That's why in between, when she was not having the job between 14 and.
my lords,
18.
for that 4,000 per month is granted by this court, my lords. We are not disputing that, my lords.
Hmm.
The only aspect is, my lords, regarding 10,000 from the date,
So for the daughter,
Yes.
till when you've paid?
my lords, from 5,000 from 3,000 from December 2015 to December 2020, my lords.
Until 1,42,000 has
Wait a
been.
minute, December 2020.
2020,
Now, when is this order passed?
Lords, the
Granting, 10,000.
10,000, my lords, on 22/6/2023, my lords,
22/6,
2023.
2023.
Yes, my lords.
Hmm.
One,
So
nearly two
even-
and a half.
Even according to you, from 2020, you are not paying.
Lords, that is what, my lords, it may be modified to 5,000 from that period also, my lords, and we will pay the rest amount from as on the date of order of this receipt, order of criminal
Let
miscellaneous.
him pay the arrears, your lordship. What is my?
50% has,
First, let him.
Understand? What we will do is, for the wife, whatever 4,000 for that period is granted, it will be as it is. For the daughter, from December 2015 to 2020 is paying 3,000. Please, you can submit, he's paying 3,000. Court has granted this 10,000 from which date?
January 2021 till her marriage, my lords.
Then on that day, you are not paying. 2020 is over.
20 over, that
Yes,
was
my
only
lords.
for MC.
My only my only prayer is, my lords, let the order be modified to 5,000, my lords, till the day of criminal miscellaneous, my lords. I will, lords,
That is from till the date of order.
yes, my lords, till the date of order. That is 22/6/2023, my lords.
So from
For the past, for the 2.5 years, my lords, I'll pay.
November 2021, what is the date? When is the date of order?
A criminal miscellaneous order, my lords, is on 22/6/2023.
22/6/20.
23.
That is how many months?
Lords, nearly
December
2.5.
2020. So this is 1.5.
3 and,
Almost 1 year, 1 year, 8 months.
my lords, December 2020, my lords, and till now, my
1
lords.
year,
That is
8 months. No, till now.
3.5 years.
No, that difference between November 2021 to 22/6/2023, I'm looking at.
Yes, ma'am.
1.5 year.
No, my lords. December 2020 was the last payment which was made in MC, my lords. The order is from 2021 January.
So you will say from December 2020 till 22/6/2023,
Yes.
you will pay,
5,000, my lords.
that is how many months?
3.5 years, my lords.
Almost 3 years.
3 years.
3 years.
Yes, ma'am.
So for how many months? 36 months.
Yes, ma'am.
36 into 5,000, and from the date of order, you will be paying 10,000.
Yes, my lords.
My lord, by the trial court, by going through the entire records, the evidence for needs to modification, he should show to the court why the order needs to be modified. In the MC, it was from 2015, 2020, it was, MC ended in the year 2020. And that time, 3,000 rupees he was paying. The court order, he did not order double order. Until 2020, 3,000 only considered.
When will you pay the arrears?
First, let him pay the arrears.
That's what.
50% has been paid, my lords. I'll pay other, my lords, within 4 to 8 days.
50%, where has been 50% paid? Only 1,42,000 until now it has been paid. 8 lakhs is balance.
My lords may give a timeline, my lords. I'll pay the arrears amount and this.
No, first you come up with the payments, then we pass an order.
Yes, ma'am.
First, calculate, I'll post this matter tomorrow.
Yes, ma'am.
You make your calculation.
Yes, ma'am.
First pay the amount.
Yes, ma'am.
Then we will see.
Yes. Lords,
Have it on Monday. Tomorrow.
Post this matter on Monday. By the time land council for the petition shall come up with the calculation.
I will also file the calculation. I will also,
yes.
No, it's not about the actual calculation.
Even
It's
the
about-
wife,
Now
my-
your client is not receiving anything.
anything.
Let's see what it, now
Yes,
if he
definitely.
comes up with a timeline, we'll see. Yes.
Yes.
Bill number 27, Mali Patil PS, for petitioner. Ravindra P.
Lords, the petition is arising out of criminal miscellaneous, my lords, which is dismissed, my lords.
Where is the respondent? Serve notice.
Is served.
We'll hear
Yes,
it, we'll hear,
expired.
post this matter on Tuesday at,
Undertake to file.
you'll hear.
Yes, Lordship, I will file the wakalat.
File. File your wakalat. Or file. Land counsel the respondent, Mr.
Spell your name, sir.
Tomorrow itself, Lordship. Moin Akhtar Nadaf.
So and so submits that he has
Moin
instructed
Akhtar
to file
Nadaf.
wakalat for the respondent. Post this matter on 13th August, not 13th. Let it be on 14th August.
Please, my lords.
Yes. Yes.
Bill number 1.
What is it? Let's see.
Number 28.
The respondent. The matter is almost settled, so it may take up on Monday. No, I'm so sorry, not settled. Almost settled. I never said fully settled. Insofar as payment is concerned, we seek some
Right,
time.
is there a scope for settlement?
Plus, there is scope for settlement, my lord, but so far as the payment is concerned.
First petition, my lord.
The petitioner, lords, he is not sure of paying the money, my lords. He is not, what he said is, he pay the money after 3 months. Now, how can it be, my lords? Unless.
We
lords-
say, my lord,
unless there is
50%.
Are you before the mediation center?
No, my lord.
Then go before the mediation center.
Lords,
we'll
it will
see.
not be settled before the mediation. Let it be here, my lord. Let it be before my lords, my lords. Let them, my lords, come out with the exact, my lords, as to what is their, my lord, settlement.
No, we'll do like this.
Lots.
We'll grant him maximum a week's time.
Yes, my
If
lord.
nothing is, then don't tell the.
No,
court
my
that
lord, no, please.
Half the way, quarter way.
Yes, yes.
Land council submits that there's a likelihood of settlement. Whether there is a settlement or not, it's been from last 2-3 occasions, same submission is made. Post this matter next week, next Thursday. By the time, if there is no settlement reported, both the parties have to address the arguments on the
Please.
merits of it.
Please, oblige, lords.
Yes.
29, Akash Sudhakar Kanare.
I'm the petitioner in one.
I am the
one case and he's the petitioner in another case. It's a case, to be very brief, madam. This is a
No,
case
Mike.
filed by the husband.
Mine is first matter. I am the petitioner. I may be permitted to, so that later she can,
Okay, no problem.
in order to avoid the confusion, my lord. My lord, the petitioner is a wife and the respondent is husband. And the husband has filed a divorce case before the family court,
6 months.
wherein after the service of notice, the respondent has appeared before the family court and has contested the matter on merits. While she has filed an application for maintenance, interim maintenance under section 24 of Hindu Marriage Act, wherein the court has utterly failed. While passing the order, the court has ordered the interim order passed by which is allowed by the court, which will be continued from the date of order, instead of passing it from the date of application.
My lord, that is one aspect, my lord. The second aspect, my lord, the wife has filed an interim maintenance amount of 5 lakhs rupees per month, my lord, wherein the court has ordered for 50,000 per month, my lord. Wherein the husband, he is a builder who runs in his own company where he constructed big apartments, wherein his annual income is of more than 2-3 crores, my lord, which is shown, wherein he has paid only 1 year IT returns in order to suppress the real income. The whichever year he has filed less, that year has been placed. That is with regarding 2021, my lord. Wherein his own income, where he has disclosed in assets and liability, he has mentioned that what is the income of monthly. He has mentioned that he pays only 8 lakhs as income tax instead of saying the maintenance. Wherein his own document says something else. His IT which he has paid, which shows that he is paying 28 lakhs income tax, wherein he has the income of 24 lakhs per year. Sorry, 94 lakhs per year. And he also has a fixed deposit of around 8 crore rupees in Punjab National Bank. And he has 4.5 crores in Canara Bank. And he has lent around 5 to 6 crores as advance towards the sites and property. And wherein he has listed around 13 properties which is existing in his name, wherein no dimension of the property is shown and the value of the property is not shown, which purposefully, my lord, it is simply they have stated, I have a Nelmangala, I have an agricultural land in Nelmangala. My lord, he has 40, 50, 60 acres of agriculture land in Nelmangala, which he has purposefully suppressed to disclose it. My lord, it clearly shows that he has not approached the court with clean hands. My lord, the court has failed to consider all these aspects. Though, my lord, the filing an affidavit, along with the document which says that he has paid an income tax of 28 lakhs. But he says in his assets and liability by stating only 8 lakhs.
Yes.
My lord,
Yes.
it is nothing but a perjury, misleading the court, passing a false information before the court. Wherein, my lord, now the husband and wife both are staying in the same house. And husband has filed alleging on so many allegations. My lord, my children have been taken to abroad. My children will be taken every year to the foreign countries and I will be thrown away in the corner of the house. I have no source of income. My lord, I should beg to my husband, and I have produced so many documents to show that.
Him to take you also.
My lord, my sincere advice, the intention of filing the application, my lord, I have been forced to leave the bonded labor life, my lord. I have, as if according to the respondent, I have no life. And they can have their luxurious life. They have Mercedes-Benz car, they have Skoda, they have all the facilities, all the servants, all the bodyguards. For me, in order to go for auto, when he comes in Mercedes-Benz to the family court, I comes in an auto or bus by taking the money from my mother and my brother.
Staying in the same house.
Same house. Same house. But I have been totally neglected. Whatever food they prepare, if it is left out, I should eat. My lord, if my children approach me and ask me to request in order to take me for a movie, I will not be in a position to do it. My lord, I was earlier, before marriage, I was working in a reputed bank, wherein I have been forced to leave my job during 2004. Now, my lord, because of this, the assets and liability clearly shows that an amount of entry maintenance, amount of rupees 5 lakhs court would have been ordered. But even in spite of producing all those records, the court has completely neglected and never looked into. And moreover, my lord, if the assets and liability filed by the husband is seen, where he's all the liabilities corner, he mentions about the children's, he mentions about himself, but he nowhere he mentions about the wife. Monthly expense ಅಲ್ಲಿ list ಅಲ್ಲಿ ನನ್ನ wife is ಖರ್ಚು ಮಾಡ್ತಾ ತೋರಿಸೋದೇ ಇಲ್ಲ. And moreover, while arguing, they says that I have kept a cash box at home. Whenever they want money, they can come and take. And I have not stopped the wife. And it is not been stated in the affidavit. And subsequently, they say that my lord, few of the property has been gifted in my name. My lord, where that property is situated, I am not aware. The document is in the custody of him and he is collecting the rent. Once for a year, I have been forced to sign for the income tax upon his request when we were together, when we are leading a good life. By taking that 1 year IT returns, but it is on the instinct of him. And moreover, my lord, like even where that property is situated, we are not aware. And the income.
What were those income tax return Returns say, how much is the income?
No, income has been shown only 5 lakhs during that time. Only 1 year it has been filed. Subsequently, I have declared that I have not filed anything. And more, my lord, they say that family court has come to the conclusion that he has kept the cashbacks and has the full access towards it and she can take anywhere, whatever you want. Then court has jumped into that conclusion. And even he is not saying so in his sustainability. It is in a verbal submission made by the council at the time of argument, and it has been, court has believed it. And my lord, by this, it is very crystal clear that the wife is entitled to the same standard of life, at least 2/10 of the income. If we suppose she is entitled for at least 1 share of the income to lead her life. My lord, even she has to look after their kids. Even she has to welfare, nourish the children, and she is entitled to take them outing, and she is entitled to lead the quality life with the children. My lord, by all these, my lord, I have been deprived of all those enjoyment and my lord. And moreover, my lord, I produced so many documents to show that now I'm leading my basic necessity.
Now these two are one by you, one by them, but they are questioning the maintenance, that is right.
They have challenged the maintenance order. I have
So
filed
you are
for.
seeking enhancement.
I have filed for enhancement.
What do you say?
One more submission. I have produced so many documents to show that I have taken gold loan. Gold loans.
You're taking gold loan.
Gold loans by pledging my gold, which is gifted by mother, everything. And I've placed all the records. 3 lakhs, 4 lakhs, 3 lakhs. I've taken loan. The burden of loan is also on my shoulder.
It's whatever money you want is for your own.
Yes,
Not for the kids.
not for the kids.
Kids are taken care of by him.
The school, everything he is looking after. But even I need to look after my children as a wife, as a mother. Because when they request me for something, I'm not in a position to fulfill it.
Yes, their assets and liability itself speaks the truth. Pot calling kettle black is the saying. The person who suppresses, he comes with another story that we are suppressing. In fact, none of the bank accounts they revealed. I have, after we filed assets and liabilities, exposed the bank accounts, then they have produced a bundle of bank accounts where she is dealing, DMAT account she has got, DMAT account will have, who has share dealings. She is doing share dealings every day. She is having 10-15,000 income in the bank statements before the court. That also she didn't produce. Your Lordship should see their assets and liabilities, where she says that she doesn't have any immovable property. I have a list of immovable property which the husband has gifted to her. Now, this is a case where it is under section 24. It is not alimony being decided here. What is his income? His company got closed out in Corona itself, 2020 itself. He is not a builder. And Benz cars, Skoda, I have produced the documents. They are 15 years old cars. He doesn't even have any new car. And your Lordship should see engineering admission he has done recently for the child, that he has paid the fees also. That is, your Lordship may kindly see how much he has paid. Everything is taken care. The court has taken note of that. 36 lakhs rupees cash has been given to her, which is circulating as money lender. That is also coming interest to her bank accounts. She has all the needs. She's living in a penthouse along with him. In fact, he's living like a servant. Cook is told to cook what she wants. He cannot even demand. If he demands, she starts aggressive attitude on the children. Children are living very happily. Children are taken very good care. Your Lordship may kindly see how engineering its education is done. The father, the husband who has not been given a life for past 11 years to 12 years, he doesn't even have a husband-wife life more than 11 years. With that also, he's taking care of her in all aspects. And whatever
For
statement.
the last 11 years, she's staying in the same house.
Same house. She's living a luxury life. Your Lordship, we should see the documents.
Who filed the MC?
My Lord,
Who filed the MC?
I filed it. I filed it because she's not, my Lord, I have taken care of her in all aspects. She was having some mental illness before marriage. That was not revealed to me. After marriage, when I came to know, I have taken her to the doctor and got her medicated. All the medical records she is admitted, all the medical expenses is taken care by the husband. Husband has done everything to lead a peaceful life. She doesn't want to lead a peaceful life. She says, I will remain lifelong with you. I will not give you a divorce also. And I will see to it that you will remain like this only. Everything when husband has done, he has not kept anything. Your Lordship should see the bank accounts, how much money she has got. Money lending she's doing. She's doing DMAT account. She's doing share business. And she has purchased recently BSNL one property, a land for which she has, if she doesn't have money and she's struggling, as he said, for an auto, she will not buy a land. I have a document to show that she's bought a land recently. This is the state of affair. And all the money has been given by the husband, including a property gifted in her name. She is enjoying the property, but she's telling a lie before the court. The court has few points the court has recorded. I will just read out for your lordship. She's an MBA graduate. She's not an illiterate. She doesn't want to go and work. She was working earlier, but now she doesn't want to work. The amount of expenses incurred, your lordship should see the order, your reasonings given by the court. Why the court decided not to give the order from the date of application, because still today he's taking care. But still the court said, okay, 150,000 rupees, you keep it for your expenses. Whereas he's keeping every month 50,000 rupees in the box, where the court advised in the open court that you should not keep cash component like that, children will get spoiled. But he said for all the expenses I have kept. So he has never deprived of money.
Instead of keeping it there, ask him to
Now,
give her.
now we came before the court, we said 50,000 is too much.
So you can give it
Because
through
he's-
account only, my lord, instead of keeping there. You can give it through account.
Now, 50,000 rupees, what was granted, he said, I don't have the company anymore. 20, I have the document to show company is bound to completely the registration itself is gone. It's closed down completely. He's only living on the rents, but he's taking care of all the expenses. He has not reduced anything. Only thing he's requesting is, we can start a decent life. She says, no, I don't want to, I will live with you. I will make your life miserable, but I will see to it that you don't get married again.
What is the stage of the MC?
MC, my lord, evidence is just commenced. They are not coming in cooperating there also. This, they filed it and they called for the lower court records, which is not required. Lower court records are not required. Any
My lord, if
document-
I have a video footage that is showing that she also accepted, no, LCR is reread because I need to show some documents to court. That upon her submission only the court has called for the LCR. Otherwise this.
Lower court records are required if some documents which he cannot produce. He has all the documents, he could have produced it before this court. He has stalled that proceedings also. He doesn't want to proceed and he wants to enhance them. The court has asked.
The best way to deal this dispute is, we'll dismiss both your petitions and ask the court below to dispose of the MC expeditiously. That's the only thing that can be
Then I
done. in
have
that.
the amount 50,000 which they are telling to pay. I'm not having that source of income like earlier.
When you're keeping 50,000 in that box to take.
I
what
was,
have you
now
got?
after this order was done, I stopped keeping that money because I'm
Then,
paying.
no, anyway, that means you have the money to keep.
No, but she also has the money. Your lordship should see the bank account. She has got every month.
Where is that bank account?
Yes, your lordship should see that. The lower court records, your lordship kindly see. The gold loan taken is also invested on the share. I'll take your lordship to the bank statements. This is the memo which they filed along with the bank accounts. That is on 17/2/23 month. Exhibit. It's a memo which has been filed in the lower court records. Date is 17/2/23. It's like this. Assets and liabilities jotege.
If you have it, please pass on.
I'll give it up. I put the flaps also, my lord, so that your lordship can see the bank transactions. Yes.
Those amount which has been shown as deposit from mother, that is from Andhra Pradesh, that is from the mother's hometown.
I'll pinpoint one.
And that we have stated in the asset and liability also, that is the loan liability which she has borrowed from her relatives, friends and parents.
Assets and liabilities, she has completely suppressed all the facts.
And the-
Suppression in an affidavit should go to perjury for them, for suppressing that she has immovable property. She also has agricultural land. She has got a demat account. She has got
She-
so much money.
the
in
council
money.
alleges that we have purchased, let them show document that we have
That is
purchased
what
the
I-
land. And let them show that,
what
my
I'm
lord,
doing.
I have a demat account
What are
where
the
I have
steps?
stated in my assets and liability,
It is there. All is flaps. I will pinpoint.
Document you're saying.
no document.
No, you said the document with regard,
Not-
that she purchased some property.
In that itself, its entry is there.
No.
I will,
In
I have
this?
written as BSNL itself, my lord. The money has gone to the BSNL site itself. If your lordship can see the file, I will pinpoint each and every.
How can you buy a property?
No, we are not at all buying any property, my lord.
I'll-
That is all the false allegation. My lord,
Document.
my lord. I have a gold loan and the property which has been gifted by husband, which is in the custody and possession of the husband only. And moreover, my lord, now at present or prior 1 or 2, 3 years before also, I have not purchased any property. My lord, and moreover, the amount wherein it is shown 1 lakh, 2 lakh, in few occasions, 1 or 2 occasions, 3, 4 occasions, maybe, my lord, which is
Your Lordship,
deposit
kindly
one.
see 126 page.
The court has asked me something. on
No,
this.
I'm answering the court because the
Which
court
page
posed the
number?
question to me, where is BSNL payment done?
Where is-
127 of the statements now. 127, if your lordship gets, it is dated, the transaction is in the left side column 230.
127.
127 is the page number, my lord. And the left hand side column, the serial number is 230, if your lordship gets it. The serial numbers of the bank statement.
Bank statement serial numbers starts from 134.
Bank statement starts from
Radha M.
121, madam. It starts from 121.
Starts from 134. Is the petition's name Radha?
Yes, yes. Petition, yeah. They are the petitioners and I am the petitioner for Mr. Nazir.
Yes.
127, if your lordship can go to the.
What is the date of the transaction? Please tell the.
Transaction date is, my lord, it is 3/12/2020. Serial number 230, my lord, in the bank statement, 230. In the left hand side, extreme left, your lordship has got the column. 3/12/2020. Your lordship.
Three 2020.
2020. Your lordship can see on the right hand side, RTGS, madam, ICICI, postal and your lordship can see that, madam.
No, it is 1/1/2020. After 1/1/2020, next transaction is 7/1/2020. There is no 3.
Serial number is 230, my lord.
There are no serial numbers here.
My lord, in the bank statement, in the extreme corner, 230, that serial number will be not. Your lordship will be able to have it.
You said the date is?
Date is, my lord, 3/12/2021. Serial number 230, my lord. Maybe your lordship.
1 moment.
That is nowhere with regarding property, my lord. My lord, previous to that,
Let
lordship
lordship see, then
the entry
your
of
one will come. After that, you can answer that.
224, wherein gold loan has been deposited in my account.
My lord, he is.
224.
Lordship is yet to trace the.
No, my lord, if the submission is so,
It's the same documents.
It
Yes,
is-
no, it has the serial number.
Serial number 230, my lord. 230. I'm so sorry, my lord. 230, the date is 3/12/2020, my lord. 3/12/2020, my lord. Your lordship gets it. Your lordship, you kindly see the right hand side, RTGS. The last word in the same line is BSNL, postal and inform. Your lordship may see the amount, 61,507, given an advance for the land. And on the same column, if you come, your lordship can come to the next 4 columns. How the investments are done in the shares. And credit column, if you see, if your lordship see 15,000, 5,000, the very next column itself. There is a share investment, the column number 231, 232, 233, 234. These all share investments and your lordship can see 15,000, 5,000. That is the way she is getting. I will also pinpoint some more huge investment what she has done. And this is all, she's rotating the money also and she's able to earn. Your lordship may kindly see some more shares which is invested. From 135 onwards, your lordship can see. 134 itself, there is a deposit of a huge money which comes back to her account. They say mother has sent. Your lordship should see this.
No, on a day-to-day basis, why one will do transactions?
All shares.
my lord, I have stated my assets and liability, wherein few of the amount has been transferred from my mother, wherein she has asked me to keep in demat account, which is of very small amount of around 1,50,000 rupees, which is belongs to my mother. Because she has no internet access and she has no worldly knowledge.
According to you, what is the balance in her account at any relevant point of time?
She's circulating. She's
So
not
how much,
keeping-
how much?
3 lakhs itself was there. Your lordship will come to the beginning.
So
of the-
maximum is 3 lakhs.
To start with, your lordship may kindly see.
No, at
It's
least
not
from
giving any
one,
amount is there.
no, one page you show and tell
Yes,
the
yes,
court
yes, ma'am.
what is the maximum balance in her account. And also let us see what is the balance
Yes,
in your
page
account.
16, my lord, if your lordship can see, page 16.
Not 60, the transaction numbers you have to.
No, the document starting page, which they are given bank statements, in that page 15, it's their own document. Page 15 and SBI statement, my lord, bank statement of her account.
You tell the court, what is it?
Page 15, her total balance amount, if your lordship can see,
How much?
it's around 1,34,744. Then your lordship come to the next page. Credit of 3 lakh rupees. Your lordship can see the credit column. Like this, she has all this money, she will take it out, again put it in the demat account and.
But anyhow, it will be varying between 1 and 3 at any point of time.
She's circulating and then.
So
you got this.
please come to your bank account.
My back account.
Yes.
ma'am. This is, your lordship may kindly see, that is, page. It's the document number 24, page 139, ma'am.
Yes. Tell the court,
No,
don't
that's
have to
the-
look at it. Please tell.
That's not mine.
How much, what is your yearly income? What are your bank balances?
It starts from page 142, your lordship.
Yes.
141 is, not 141, 142. So my account also, your lordship may kindly see.
How much is the amount?
It's almost closure, if I come to closure. My lord, in his account, what happens is the properties which some MOU and all he has entered, some money comes to his account.
Whatever it is.
So if,
Ultimately, what is it?
I'll just take the plan, does it?
It's all in lakhs and crores, my lord.
My lord, your lordship, you kindly come to page 24 now. That is my assessment of 2021-22, in which my annual income I shown as 91 lakhs. And my taxable income is 29 lakhs. So this is yearly. So I have to take care of all the expenditure, the children, house, everything, which has to be sitting within her medical expenses, everything is taking care. So he has not deprived her of anything. Only the sadness is 36 lakhs rupees, it was accepted in the open court.
So
before the
according to
family
you,
court.
no, according to you, she do not require any money.
She doesn't require any money. She's circulating the money in the shares and she's money lending. All the thing is in their own document, it is there.
We'll pass orders tomorrow.
Please.
Tomorrow for orders.
Please.
May I make one submission? In the same document which is filed by him in page number 26, my lord. But this amount now, what it is revealing, that has not been stated in the assets and liability. And moreover, my lord, in page number 26, I'm sorry, in page number 28,
Yes,
fixed deposit in Punjab National, 7 crores 13 lakhs 41,000.
yes.
And in Canara Bank, 3 lakhs 32,000. And my lord, if it comes to left-hand corner of the, wherein he has advanced around 4 crores 23 lakhs. advance which is yet to receive, which he has given already. My lord, the loan which, yeah, that is of only of around 90 lakhs, my lord.
Yes, we'll consider tomorrow, we'll pass orders, postal orders tomorrow. Yes, next.
My lord, and the order is, my lord, the court has ordered to give maintenance from the date of order, my lord, which is is arbitrary, my lord. From the date of order, it has been ordered.
Ladies and appear for the petitioner. There are two petitions filed against each other.
How many petitions you people will file? You can see each other.
There are a lot of material to point out that this kind of order whereby I am required to make the payment.
No, I'm telling both of you.
Yes.
And look at the order. If this is the manner in which you are time and again coming to the High Court for no reason, you both of you think about it and argue. I'll post these matters tomorrow. Exemplary costs I'll impose
Please.
tomorrow,
Please.
30-31. Yes, next.
May I just enter the compilation which I am relying upon?
Tomorrow you will see. I'm indicating.
Not.
So both. Yes.
31.
For the respondent, my lord was pleased to refer both the parties to Nuisance. If the report is placed on record, my lord. And I have also filed another writ petition challenging the very same impugned order. That writ petition may kindly be clubbed together and heard.
Give the number.
Please.
Post this matter on along with so and so on 14th August.
Much obliged.
Next 32.
32.
Respondent. Lord, your lordships directed me, station rate of the kid in the police station, Lord. Lord, sir, what's
Respondent.
I'm for the respondent.
there is one other judgment of the.
In front of the court also, Your Honor, ready. I am ready to take the child in front of the court itself also, Your Honor. But what has been
Child
passed
should
by
agree,
order,
Lord, that's.
but take the child visitation rights through police station, Your Honor. That is, if my senior counsel is saying that it is not the proper way, I am ready to take the child before in front of the court, Your Honor.
What in front of the court?
So, saying that the in front of the
No,
court.
the order, the court has passed an order. What is this judgment?
Lord, that
It's
is
not
apex
a
court
final-
judgment
final-
where I submitted, Lord,
Please, no, it can't be. Why should the parties go to the police station?
So not, parties are not going to.
Let there be some other place. Which place?
It's in court, in court.
Which court?
In family court, my lord.
What is the age of the child?
The age of the child is 7 years maybe.
Why it should be in the court?
It's not court, Your Honor.
brought the
Court has
child.
been ordered for the child, mother to.
I have brought the
Take
child also,
child
Lord,
from
child
the-
should also get.
Huh?
I have brought the child also, Lord. Child should also get acquitted with the father. She never seen the father. Suddenly he wants to take the child along with him and he wants to swear.
You are appearing for the mother.
Mother, please. Lord.
What is the order passed for the court?
Lord, court says, Lord, earlier there was an order, Lord. He has to visit in the court premises. Now the court on the application filed by the husband modifies it that he is permitted to take the child along with him.
No, he says that he'll meet in the court, in the
But-
mediation center or whatever
Your
that,
Lord, my only respectful submission, I have no objection for that. But provided the child should agree for it. Lord.
My lord.
what child should agree?
No, my lord. This is false.
child-
Falsification, my lord.
If given a chance to the mother, no child will agree.
It's not that, Lord.
Will not
What I have pointed out to your lordships on the last
No,
occasion,
your order is
Honorable
okay.
Apex Court is very clear, Lord. The
Elaborately,
courts
by
has the
avoiding
power,
the
one
court
nimsha,
also, my
sir,
lord.
one nimsha, sir. Court has the power to interact with the kid, to find out the comfortableness of the kid to go with the father. It's a female kid.
Where is she going?
Lord,
Where is she going?
no, that to meet the father also.
That if,
I
if
can't
the
co-
girl is saying
see,
that I will not meet the
As a
father.
mother, she cannot compel her. If the child decides, I have no objection. As a mother, I can't compel. If the child decides, I have no objection. But the court should not take that as a
Problem
weapon.
to the child to meet the father.
I don't know, Lord, child has to explain. She says that she is not.
Child is
No,
not
child-
the- Child is
Let-
too small to explain all these
Lord,
things.
that's what the apex court says, Lord. That's what the apex court says.
Apex court has stated so many other judgments are there. You're only looking at what is coming, what
Lord,
is,
this is the,
advantageous to your client.
no, Lord, it's not that, Lord. This is the stigma, what it has been
No,
fixed by the honorable
the
apex
apex
court, where it
court
says
as
that
well
the
said,
court has
the
to.
apex court as well said, these kind of things amounts to parental alienation.
You know, Lord, but at the same moment, we cannot harass the kid. The kids should be comfortable. No, my lord, mother will not interfere. If the kid is comfortably going with the father, we have no objection.
Definitely.
My lord, my,
To that extent, will modify the order here. Otherwise, if the mother comes up with these kind of things, then in your opinion, I have to pass some other order.
no, my lord, what my respectful submission is, my lord, let him visit the kid in the comfort, wherever they comfortable to the kid for 1 hour or in the court mediation center or court premises.
Take that and show that it's covered.
No.
Then you come back to the court.
No, like, it's not that. No, otherwise, where should I leave the kid and the kid should, please,
To that extent, will modify the order.
please, let him visit the kid and it should not take the kid if the kid is not comfortable. No, he says that he wants to take the kid to home, all those things he has written.
My lord, when they are failed to bring the child before the family court, Your Honor, then I have initiated the contempt.
Today, my lord, I'm
also, my lord.
sorry to say this, my lord, today, the Honorable Trial Court, they have filed a memo saying that direct the Gulpet police to secure the kid and produce it before the court. That is the memo
the
what is
sake of-
filed.
Definitely, my lord.
Monthly once I'll take to the court and let him get a.
My lord, there are 2 times in monthly. Yes, Your Honor.
Court will not function. First and third set. First and third set.
Granted the state to the father. Any on first and third Sunday of every month, for a period of month, pending schools of the case, in the presence of the immediate relative of the petitioner means mother or father?
Mother, my lord.
Mother.
Relative of the mother, also lady at the gate. Why you
That's what we have to
Court has
take
been
care of the
passed.
kids' interest. I'm sorry to say this, but family court is going completely biased. The police has to go, the relatives have to go. Completely ignore the interest of the kid.
The responding to produce the child for the local police station. The state police station on the of the month to taken the interim trustee. The resident of the given the review of the book. The profit related to the better response. The counsel for the mother subject was published that because of the order passed to the mother of the child has to go to the police station. First and third Sunday. Which is not for the fact. Submitted that the mother is always interested. She's always cooperating. She's always cooperating to she is very cooperative to the father to exercise and take and it's something that we cannot be the police. All these conditions that the report of the report not in the interest of the minor and some place which is in the interest of the minor they decided the council responding to the objection to meet the court premises considering all this disposition appropriate monitor the order dated
First.
The father can meet the child on first and the third Saturday every month between 10 to 2 p.m. in the court premises. Is there any movement that will be?
No rooms, my lord. There. So we'll take the child in his position, my lord. Take the child in his position, my lord, as per the court order, my lord. But there, no police station, not police station, my lord, but position. Local place means,
Lord, I'm sorry, my lord, there's no 4, my lord, because it's got a school in the morning. My lord. Saturday, so.
That is the reason.
Up, you know, up to 1 o'clock, she has got a school. And then 2 to 4, they can. No, it's working. All the Saturdays, no,
That
it's
is
working.
as far as any Sunday, my lord, is because child is.
La
going to
Sunday,
school.
mother has got the
Sunday,
other
ma'am.
works to take care of.
Sundays.
Saturdays is the best, lot 2 to 4, anytime, 2 to 5 also, no.
Yes, Your Honor. 4 hours only.
1 to 4, 1 to 5 o'clock, I know. In the court premises.
No, court premises are.
Well,
It's not that there's mediation center or something.
Yes.
There's an all where they can accommodate. Mediation center is there.
Right.
Mediation center.
Because they are not cooperating in the mediation center, my lord, because earlier order, the honorable court was passed an earlier order. She was not cooperating there only.
They are not. They are not, then we will do one thing, we'll keep this ready. The post is smarter next week. Post is smarter on. Just 13th, on 3rd and 10th Saturday, the petitioner, the father, the registered state right, the premises of the.
No, 10th mediation center will not work. Second Saturday mediation center will not be. Third, I'll take the kid there, Milad. Let it come on 13th. Good?
Second, then busy on that Saturday.
This Saturday is coming,
Third,
Saturday is ready to take the child.
Third, I will drop the child in the mediation center. Milad. Let him interact with the child. Let him go.
Between 1 to 4, 5 o'clock. Also smarter on, and in that case, we come up with, we'll see, tell the mother, she has to cooperate and court is not.
No, I will take the kid and I will drop in the mediation center. Please.
And you will take away the child from the any other restaurant or some other hotels.
Cell number 33. I feel tomorrow. 34.
This, the building construction has been stopped, my lord. Maybe taken up tomorrow. The 34, my lord.
35.
35.
All moved matter, my lords. I have moved this matter to submit the itinerary. Your lordships are directed. Please, I shall do it right away. My lords, the visitation would have to continue.
The grandfather, 85 years old, is having major problems, got discharged yesterday. That is why only one visitation we did not go.
We'll have tomorrow morning. A meeting now.
My lords,
No, not tomorrow, your lady. Next week.
Monday.
Next week, 6th, please, 6th. On Monday, I have your own mandamus matters, please. I have 3 matters, that is one. 6th.
6th is.
Tuesday.
Pleasure.
Cell number 30.
Check and acknowledge.
36.
Maybe on Monday, Monday or Tuesday. Okay.
36.
For the opponent in this case, my lords. 36. Please, my lords. Please, publish.
Your Lordship, 39, we have filed a memo for withdrawal. So. Serial number 39. No, Your Lordship, we have filed a memo for withdrawal as not pressed.
Is not. Sorry. 38 may make one more submission. The name is not been shown, even though the notice has been filed on.
Name right. Name right, Barkudis.
My lords, 13, serial number 13. Yes, my 13. Yes, my lord. No, my lord, I'm not able to come Monday.
Cell number 40.
40, my lords, kindly repeat it on Monday.
41. Still number 41. Utrappa, non-finishing of cover existence of emergency. 42, awaiting of service in respect. Then number 43, disposed, 43 disposed, 44.
For the petition.
awaiting
ಟ್ರಯಲ್
of-
ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ಆಲ್ರೆಡಿ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ದಿ ಕೌಂಟರ್ ಫೈಲ್ ಮಾಡಿದ್ವಿ. Yesterday I filed counter. Serial number 31 interim order may kindly be extended.
Item number 30, matter is kept tomorrow. Can we request matter could be taken high on board because our court matter is there in the trial court at 3 o'clock tomorrow. I will make an attempt to satisfy.
Serial number 10.
Madam, serial number 10. ಪಾಸ್ ಓವರ್ ಆಗಿತ್ತು ಪಾಸ್ ಓವರ್ ಆಗಿತ್ತು ಬೆಳಿಗ್ಗೆನೆ ಪಾಸ್ ಓವರ್ ಆಗಿತ್ತು ಮತ್ತೆ ಕರೆದಿಲ್ಲ
ನೇಮ್ ಚೇಂಜ್ ಮಾಡೋದು.
A. Chandrachud, appellant
ಇದಾರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾ ಇದಾರೆ ವೇಟ್ ಮಾಡಿ ಹೋದ್ರು.
ಅದ್ ನಮಗ್ ಗೊತ್ತಿಲ್ಲ. ಅದ್ ಆಗಾಗಿದೆ.
ಈಗ ಆನ್ ಮಾಡಿದ್ರಲ್ಲ ಮೇಡಮ್.
ಇಲ್ಲ ನೀವು ಆಫ್ ನೀವೇ ಆಫ್ ಮಾಡ್ತೀವಿ.
ಚೇಂಜ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಗ್ರೀನ್ ಆನ್
ಅದನ್ನ ಚೇಂಜ್ ಮಾಡ್ಕೊಳ್ಳಿ. ನೇಮ್
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕೊಡ್ಬೋದು ಇಲ್ಲ ಅವಾಗ ಕರ್ದಿಲ್ಲ ಸರ್ ಬೆಳಿಗ್ಗೆನೆ ಪಾಸ್ ಹೊರಗೆ. ಹಾ ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 10
ಯಾವ್ದು ಇಷ್ಟು
ಜೋರಾಗಿ
ಸೀರಿಯಲ್ ನಂಬರ್ 10.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 10
32 78
10 ಏನಾಯ್ತು? ಸೀರಿಯಲ್ ನಂಬರ್ 10.
10 ಪಾಸ್ಡ್ ಓವರ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಸರ್
ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ.
ಡೇಟ್ ಕೊಡ್ತೀವಿ. ಎಲ್ಲ ಜಾಗ ಬಿಡಿ. ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಇದೆಲ್ಲ ನಾವು ಮಂಡೆಗೆ ರಿಪೀಟ್ ಮಾಡ್ಸಿ. ಮಂಡೆಗೆ ಎಷ್ಟಿದೆ ಡೇಟ್ ನೋಡು? 5ನೇ ತಾರೀಕಿಗೆ. ಅಲ್ಲ ಸರ್ ಅದು ಓಲ್ಡೆಸ್ಟ್ ಮ್ಯಾಟರ್, ವಿ ಕಾಂಟ್ ಕೀಪ್ ಇಟ್.
ಇವತ್ತು ನೋಡಿ 10 ಗಂಟೆಯಿಂದ ಎಷ್ಟೊತ್ತು?
7, 8, 9, 10 ಅಲ್ವಾ? ಎಲ್ಲ 5ನೇ ತಾರೀಕು ಡೇಟ್ ಗಿವನ್ ಮ್ಯಾಟರ್ಸ್ ಎಷ್ಟಿದೆ ಅಂತ ಗೊತ್ತಾದ್ರೆ ವಿ ಕ್ಯಾನ್ ಅಸೈನ್ ದ ಡೇಟ್ಸ್. ಅದರ್ವೈಸ್ ಇಲ್ಲ ಅಂದ್ರೆ ಸುಮ್ಮನೆ ಅವತ್ತು.
ಹೌದು.
ಯಾವ್ದು ಏನ್ ಸಬ್ಜೆಕ್ಟ್ ಇದು ನೋಡೋಣ? ಇದು
ಅದು
ಆರ್ಬಿಟ್ರೇಷನ್.
ಟ್ಯೂಸ್ಡೇ ನೋಡು. ಮಂಡೇ 5 ಬಿಟ್ಟು 6
ಮೇಡಮ್ 9 ಆಯ್ತು.
5ನೇ ತಾರೀಕು ಎಷ್ಟಿದೆ ಸುಮ್ನೆ ಅಲ್ಲೇ ನೋಡು.
ಬೇಡ ನಮಗೂ
ಒಂದೇ ಒಂದು ಡೇಟ್ ಮಾಡಿ ಬ್ರಾಂಚ್ ಹೋಗ್ಬೇಕು. ಇದು ಇದು ನಾಳೆದು.
Serial number 44.
ಎಷ್ಟಿದೆ ಅಂತ? ಅಲ್ಲ, ನೆಕ್ಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ. 26 ಅಂದ್ರೆ ಇವಾಗ ಇದು 6 ಹೋದ್ರೆ 32 ಆಗುತ್ತಲ್ವಾ? ಅದರ್ ದನ್ MEC ಕೇಸ್ ಟ್ಯೂಷನ್ ಅಲ್ವಾ ಇರೋದು? ಅದು 6, 8 ಎಲ್ಲ.
Madam, serial number 44.
ಗ್ರೀನ್ ಇದೆ. ನಾವು ಅದು ಆಗ್ತದೆ ಇಲ್ಲ ನಾವು ಅದನ್ನ ನೀವು ಆಗ್ತದೆ ಎದ್ದು. ಆನ್ ಮಾಡಿದ್ದು ಬೆಳಗ್ಗೆಯಿಂದ ಆಗಲಿದೆ. ಯಾರು ಆಫ್ ಮಾಡಿದಾರೋ? ನಾವು ಮಾಡಲ್ಲ ಹಂಗೆ.
Serial number 44. And someone said, ಏನ್ madam?
44
4.
ಆಫ್ಟರ್ ಸರ್ವಿಸ್ ಆಫ್ ನೋಟಿಸ್.
Service.
ಅವೈಟ್ ಅಂತ ಇದೆಯಲ್ಲ.
But madam, ಅದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ಗೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿ ಕೌಂಟರ್ ಫೈಲ್ ಮಾಡಿ ನಿನ್ನೆ.
ಮಾಡಿದ್ರೆ ಅದು ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿ ಅಂದ್ರೆ ಸಮನ್ಸ್ ನೋಟಿಸ್ ನ ಇದೆ, ನೀವು ಆಫೀಸಲ್ಲಿ ಹೋಗಿ ನೋಟಿಸ್ ತಗೋಬೇಕು. ನೀವೇ ಸರ್ವ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ, ಅದಕ್ಕೆ ಅದು ಪ್ರಾಬ್ಲಮ್.
ಹೌದು.
ಅಂದ್ರೆ ಟೇಕ್ಔಟ್ ನೋಟಿಸ್ ಟು ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ಅಂದ್ರೆ ಆಫೀಸ್ನವ್ರು ನೋಟಿಸ್ ರೆಡಿ ಮಾಡ್ತಾರೆ, ಅದನ್ನ ತಗೊಂಡೋಗಿ ನೀವು ಅಲ್ಲಿ ಸರ್ವ್ ಮಾಡ್ಬೇಕು, ಅದಕ್ಕೆ ಮೆಮೊ ಹಾಕಬೇಕು. ನೀವು ಸೋಮೋಟೋ ಸರ್ವ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ.
ಇವಾಗ ಏನಾದ್ರು ರಿಸೀವ್ ಮಾಡ್ಕೊಂಡು